It would take costs out of, it would change the allocation on the TS large class. So, I'm not exactly sure. There's, 1,000 different moving pieces, but I think that, it would probably improve the TBF class. I'm not exactly sure about the impact on the large.
Suffice it to say, it would impact the calculations to some
Absolutely.
extent. And we
Yes.
don't, do we have any calculation that would show what that impact would be?
No.
Okay. Is that something that would become available to you after this rate case and after rates are stabilized?
Yeah, I think that it's analysis that could be done and should be done.
Okay, Mr. Meekum asked you about the load factor of the TS class. And if I have this right, I think he indicated that the collective load factor of that class was somewhere in the range of 70%.
That's right.
You recall that? You indicated that these small TS customers are comprised of things like hospitals and schools, et cetera. Are those the types of customers that would have a high load factor?
No, any customer that's using the natural gas primarily for heat would have a low factor, so a low load factor. So a customer like a school would probably have a load factor that's closer to 23, 24, not anywhere near 70.
And where would that line up relative to, say, residential customers?
Residential customers typically come in around 22.
So is it a fair statement that these small TS customers that Mr. Meekum was asking about are much closer in the load factor they have to residential customers than they are to the large TS customers?
Absolutely.
Subject to check, would you agree that the large TS customers' load factor hovers above 90%?
Yes, that seems reasonable.
So would you agree with me that that's a big difference between the small TS customers and the large TS customers from the context of the load factor they have?
Yes.
Do you think that's a reason to distinguish between the two of them?
Absolutely.
Okay. I want to talk just briefly about Mr. Meekum asked you some questions about the reason there's this sign-up window for customers to sign up to the TS class. Do you remember those questions?
Yes.
Could you just reiterate, what is the planning you have to do as a company for the year that you have to do from a gas purchasing standpoint that you were trying to explain? Would you just lay that out?
Yeah, from a gas purchasing standpoint, the gas supply group will come to the rates department. They will get our forecast of what firm sales will be. We have personnel that forecast that demand. They then use that, and they have a model that they will run to determine how much gas should be contracted, how much should be with different contracts, and they'll also determine how much should be purchased based on spot prices, how much of it should come from Wexpro, those kinds of factors. And then that's what we're using to contract for gas.
So if you enter into contracts, and if you decide from Wexpro's standpoint what you're going to drill that year, and then you have a significant departure of TS customers to the TS class, what happens to the costs of those contracts and that drilling that would have been paid by the TS customers who have just left?
It would remain in the sales customers. It would be paid for by the sales customers.
So if the TS customers leave, the GS customers are left to pay the bill, their portion of what was being planned for those TS customers.
That's correct.
Okay. By contrast, if the commodity rate increases and they were able to jump right back into the GS class, what impact would that have on the GS class in that scenario?
I think they would be, well, those customers that are switching back are taking advantage of a free hedge, is basically what they're doing. But those customers would then be contributing to the costs.
Thank you very much. That's all I have.
Thank you. Mr. Jeter, do you have any recross?
I do not. Thank you.
Mr. Snar?
No.
Okay, thank you. Mr. Russell?
No, thank you.
Mr. Meekum?
I have a couple, thank you. So, Mr. Summers, you refer to the chart on page 22 of your testimony showing the growth of the TS customers. What's been the percentage growth in the TS class throughput?
It's not shown on that chart.
No, I know it's not, how much difference has that made?
From a throughput basis, they are not nearly as big. Actually, hold on.
It's comparatively small, is it not?
No, in fact, if you look at that chart on page 22, the fact that that red line, the average decatherms per customer, the fact that it keeps going down every year shows that as they're coming on, they are smaller customers. They don't have a very high usage.
So the throughput percentage doesn't come anywhere close to the increase in the number of customers,
That's correct.
okay? And what's been the percentage growth in the TS demands?
In the TS demand cost,
Yeah,
I think that we talked earlier and looked at DEU Exhibit 4.14, and we showed that there was almost a 100% increase in the demand charge. But as far as the increase to demand, I don't have that.
would it be relatively small? Given the
I think
kind of
that
customer that's
seems
transferring?
reasonable.
Sorry,
I think that seems reasonable.
okay. And then Mr. Saban talked about the fact that ANGC Exhibit 2.01R reflects existing rates, true enough.
That's correct.
And obviously, we agree that you've proposed to bring the administrative charge down. But as you point out, there's also an increase to those customers. So you really don't know what that number is.
That's correct.
Conceivably, well, we won't go there. Let me ask about the planning that you listed or enumerated and explained for why the one-time window is essential. Didn't you describe what every other company does, including Dominion, with the exception of Wexpro?
That's a big exception. I mean, Dominion, when you're looking at other Dominion companies, there's a big difference between Dominion companies. For example, Dominion East Ohio is a completely unbundled company. They all of their customers are transportation customers.
Well,
They're absolutely going to have a different process than what Dominion Energy Utah is going to have. So we are just saying the one thing that makes Dominion Energy Utah unique being Wexpro is just one thing. It's a big thing, and I think it's appropriate to plan so that we can manage those supplies. And again, like I said before, this process that you're proposing to change has not prevented people from coming to the class. I just don't see any reason to change it going forward.
hasn't it worked in other areas, or do you know the answer to that?
Well, I'm assuming that it works
Okay.
for other companies.
And then this, this analysis that you want to do over a 3-year period, why wasn't it done for this case?
It's a fair question, and I think that it happens in every rate case that you look at, that you wish that you had just originally analyzed the final result and filed that. But we did do a lot of analysis over the last 3 years, but as with the class constantly changing, by the time we got to 2019, everything that I had proposed in 2016 just didn't work. We got to the point in preparing this case where we said, we've got to back away from what we proposed in 2016. The class has changed so much that it no longer works. What I need to do now is fix the things that I can right now, and that's why I did the three-step approach, saying we know we need to get the class to full cost. That's going to fix a part of the problem. Let's also stop the growth in the class. That's going to be another part of the problem. And then that gives us the chance to really look at rate design in 2019. It's I was actually thinking about this just yesterday, and I was thinking, you know, it's easy to Monday morning quarterback it and say, you should have looked at this all along, but we didn't see it coming, and if I had, I'm sure I would have proposed it. But I think we need the time now to make sure that it's done right.
But by not planning, doesn't that penalize those that would move to the TS class? In other words, it could have been done, there would have been no moratorium, now we've got this in front of us.
I would like nothing more than to have had this fixed in this case. I really would. But it's not ready. I've already talked about that at length. There's one proposal out there that was based on a 35,000 decatherm split. I'm not convinced that A, it should be split by size, or B, that it should be split at 35,000 if it is based on size. I think that we need to look at, I think that demand, the way the customers use the system, I think those are more important things to look at. It could be that you just have a firm transportation class moving forward, and it doesn't matter what size the customer is on. If they have a low load factor and if they're using the system seasonally, maybe it makes sense for them to have a summer-winter differential instead of a firm demand charge. We would just treat them as firm customers. I'm talking ideas here, but there's a lot of analysis that still needs to be done. And so if I could, go back in time knowing what I know now, things might be different. But that's the point of a rate case, is to put the ideas out there, get the ideas. I think that all of the parties have put out good proposals or good information, good ideas that we can use, and going forward, we'll use that.
One last question. If you're not convinced that the 35,000 decatherm level is the right split, why is the moratorium based on that?
The 35,000 decatherm, it's kind of an interesting history, because when we proposed 35,000 decatherms, it was originally to be a floor for the TS class. So you had to have minimum usage that above 35,000 to be even considered in the class, right? So that's where we proposed it, and that was based on mostly us looking back in history and saying in 2010, that's kind of where customer usage was at, right? So we're saying if that's where it's at, let's make that the floor. I realize that's not a really quantitative analysis, but we're saying that will get us the objective that we need. That'll help stabilize the class. So that's how 35,000 started. And then in the direct testimony of, I think it was Mr. Higgins, proposed that it be a moratorium rather than a floor. And so we agreed to the 35,000. Then that 35,000 decatherm amount was used for discovery to calculate that data request, for lack of any other place to split the class. So that was just their way of saying, let's do the break there. And so it's kind of what started out as one thing has morphed into other things. And so no analysis has really been done to say if 35,000 decatherms is the best place to split the class.
You talk about stabilizing the class, but doesn't it pretty much end the class? As far as new customers are concerned, it's over.
It's not over. It's a temporary moratorium. For 3 years, I'm saying I need to slow that growth. I can't do an analysis every year based on what customers have been added to the class. It can't be done. We'll be in the same position again next time. We'll have data from the 2019 case that we'll all have looked at. We've all done it, but then by the time I get to 2022, it comes time to put together rates, I'm gonna have completely new information to deal with.
Thank you. I have nothing further.
Are you indicating that you want to, oh, sorry, I haven't gone to Captain Freeman yet, sorry.
No follow-up, Chairman.
Okay. Were you wanting to do
Can I
some?
ask just one question?
Okay.
As it relates to the moratorium, are you seeing substantial growth in the small TS customers or the large TS customers?
It is the small.
So the moratorium, as you're proposing it, would temporarily stay the flow of that large group that is causing the problem and making it so you can't do the data.
Right.
Okay, no further questions.
Okay. Does anyone have any follow-up to that? Okay, Commissioner Clark, do you have any questions?
Thanks. Sticking with page 22 for a moment of your direct testimony, Mr. Summers. At line 575, I see the sentence that, and we've been discussing it, since rates were set below cost, there was still an incentive for customers to switch from sales classes to the TS class. Hypothetically, if in this proceeding the commission orders a path toward and a path that results in full cost allocation, one of the step processes that has been proposed. Is it your testimony that that action won't dampen the trend that you're
growth.
seeing, dampen the percentage of growth that you're seeing in this?
I think it would probably have some impact. If it were an immediate impact, if the rates were to jump to full cost in March of this year, I think that would have more of an impact on how many customers would join the class. But if you're doing the gradual approach, I think that effect is diminished at least somewhat.
Thank you. Separate, there's a different issue now, but still principally with regard to the TS class. With respect to administrative charges, is there studies that you performed regarding customer representative time and how it's devoted to customers that have significantly different throughput rates? Do you have any analytical or quantification of that difference?
We don't have any quantification. The big costs that goes into the administrative charge is for customer support, basically, right? So you've got the account reps that work with these customers. When I talked with them, and like I said, this isn't a quantitative analysis, but just said, where do you spend your time? Are you spending your time on large customers, or are you spending it on small customers? And they said it's really kind of equal. Right now, there's so many small customers that it takes a lot of time to work with them, whereas the large customers are more sophisticated, and I think that they don't take maybe as much time to work with them.
So on a per customer basis, there'd be a lot of difference, but if you look at them in the aggregate, placing them into two rough separate categories of usage, you'd say
I'd say it's
your
It's fairly
anecdotal
equal.
information is it's similar.
yes.
And the kind of analysis that you're talking about performing, to better understand cost allocation in this class. Would that include a more analytical approach to customer representative time, for example?
Absolutely. In fact, I hesitate to throw out what just comes through my head, but assuming these customers were sales customers before, and they didn't have, an administrative charge, they didn't pay a demand charge. Some of these things were, their rate design was a lot more simple. It could be that you look at those administrative charges for those customers, and rather than doing an administrative charge, you could lump that into the volumetric rates. Now, I know that that's been discussed even with the ANGC. They've proposed that they want the administrative charge to go away altogether. I don't think that that's the best thing right now. I think that the administrative charge collects some costs, some real costs. I mean, it is a cost-based charge. And for the customers that rate was originally designed for, it's a suitable charge. I don't think it should go away. Of course, the overall effect, if the admin charge were to go away, is that volumetric rates would go up. You're going to collect the same revenue requirement from whatever rate design you use.
Now, a separate subject regarding the design day allocation factor as contrasted with using an actual peak day usage factor. Is there anything extraordinary in developing an actual peak day factor for use in your studies?
The extraordinary thing, and I'll just point out that both of these methods would require estimates.
Right.
All right. So the extraordinary thing with actually calculating a peak day factor just based on the highest send-out day of the year would be that we just don't have hourly information or daily even information for GS and FS customers. So we don't know exactly how much to do. Now, if I were to estimate how much the GS class and FS classes were using on that day, chances are I would use the same method that I'm using in the design day. So I think if you did use the highest send-out day, you'd get a similar result of what you would get by using the design day to begin with. What I like about the design day, though, is that that's what we use in the IRP every year, and that's consistent. It just shows a consistent number from year to year, whereas the highest send-out day of the year could be high some years, could be low some years. I just think it's more consistent to use the design day that we use in the IRP.
I understand the preference you're expressing, but I want to make sure I understand the full implications of your answer. And what I think I'm hearing from you is that if the commission were to request or direct that you develop a factor that would be representative of actual peak day usage rather than design day usage, that you can see a path to doing that in a defensible way. Is that correct?
I think it could be done. I just think it would give a similar result to what the design day is.
Regarding the F230 allocation factor, and you, I think, testified that you saw logic behind the 6832 split. Is that logic different than the 60-40 split? Can you distinguish or articulate a difference in those two relationships or ratios that has a logical underpinning?
Yeah, the 60-40 weighting really is just a middle ground, and we've never put any quantitative analysis into that. It's just been a matter of the small users, the residential customers, that's typically the division in the office, are usually proposing a 50-50 weighting, and the industrial users are usually filing something or requesting something that's closer to a 70-30. And so the companies was just the middle ground. We said, if there's no agreement on how to do this, then this middle ground is the way we should go. So when I'm comparing the 60-40 to the 68-32, we're talking a number that was just used as a compromise and comparing that to a number with quantitative data behind it, which is what the 68-32 has.
And the data has reference to,
Yeah, the data that's used for the 68-32, the way that that's calculated is we're looking at the overall system-wide load factor. And so we're saying if the system is being used 68% of the time to meet the average demands of customers, then that would put the other 32% onto peak. So it's tied into system-wide load factor.
with regard to TS rate design
Okay?
and the testimony that you gave in reference to Mr. Higgins, I think a surrebuttal, where he pointed out that it would be more appropriate to scale each volumetric block rate
Right.
by an equal percentage. We don't have a model or modeling results that reflect that outcome in this record, do we?
I don't think you do. You have summary exhibits from, I think from Mr. Higgins, but the company could produce a model that would show that result.
So that's my question now to council, is there a way that can occur?
I think I'm hearing yes. I would need to understand the time frame by which we would need to do it, but we could talk over lunch and come prepared with an answer as to how long that would take to prepare.
Right, and perhaps that conversation could include not just your clients, but other counsel as well, so that maybe there's something that could be agreed upon.
Sure.
Thank you. That concludes my questions. Thank you very much.
Commissioner White?
I have no questions, thank you.
Thanks.
Mr. Summers, are you aware of any anything that this commission or another commission has done that's analogous to the moratorium you're asking us to implement for TS customers, that's been done for the same purpose?
I am not aware of anything that other companies have done. This was brought about by I think the unique circumstances of this case. And as we're trying to figure out how to best solve this, that's the solution that came up. So I'm not aware of any others.
Okay, thank you. I think I just had one more. Oh, so after the 2007 general rate case here, that impacted peak demand allocation to interruptible service customers, what incentive existed between that case and the 2013 case for customers to move from transportation service to interruptible service? Was there a financial incentive during that period?
I'm not sure what existed between 2007 and 2009.
And I recognize that's a bit of an unfair question to ask
Yeah.
about something over 10 years ago, but just if you have any.
And what I'm thinking is I believe that the 2009 rate case was settled as well. So there's probably only a 2-year period where that was the case. And I would have to double check on that to see what that settlement stipulation included. But I know in 2009 we did propose that we change that.
Okay. Are you aware, though, of any other financial incentives to move to interruptible service other than peak demand allocation?
No. No, on
In
the,
terms of comparing transportation service to interruptible service?
oh. So you're asking if if a transportation customer had an incentive to move to interruptible service, is that?
Are you aware of any other financial incentives other than peak demand allocation
No.
between the two?
I'm not. No, and that's why I think that it's important that we do this, is so that there is an incentive. So otherwise there's no point in having an interruptible class. Now, that class is down to about 20 customers right now. A lot of those customers have gone to the transportation service over the last decade or so. But for those customers who still want an interruptible option and want that benefit, I think that there needs to be a distinguishing factor. And I'm not aware of anything besides the allocation of design day costs that would make that distinguishment.
Okay, thank you for your testimony today.
Sure.
And noting that our last hour and a half or so have been a little bit disruptive, I think we'll still go ahead and take a break now and reconvene at, why don't we say 1:15? By that clock. I know that clock's a little bit ahead, but we'll reconvene at 1:15 on that clock. I think we'll start, and we're ready for Dominion's next witness.
Thank you. The company calls Jessica Ibsen.
Ms. Simpson, do you swear to tell the truth? Yes. Thank you.
Ms. Ibsen, will you please state your full name and business address for the record?
My name is Jessica Ibsen. The address of our work is 33. I'm sorry. Jessica Ibsen. The address is 333 South State Street, Salt Lake City, Utah.
And by whom are you employed?
Dominion Energy.
And what position do you hold with Dominion Energy?
I'm a regulatory analyst 3.
Ms. Ibsen, are you the same Ms. Ibsen that filed, pre-filed direct testimony in this docket that is labeled DEU Exhibit 5.0 with accompanying exhibits 5.01 and 5.02?
Yes.
And do you adopt the contents of those documents as your testimony today?
Yes.
The company would move for the admission of DEU Exhibit 5.0 and accompanying exhibits 5.01 and 5.02.
Okay, if anyone objects, please indicate to me. And I'm not seeing any objection in the room, so the motion's granted.
Thank you. Ms. Ibsen, can you please summarize the testimony you've offered in this docket?
Yes. The purpose of my testimony and exhibits were to clean up and propose modifications to the company's tariff. I have made a summary of 9 applicable changes being proposed in this docket. Number 1 is adding a manual meter reading fee of $20 per month. This would give customers an option when it comes to their perceived health concerns to have their transponder removed from their meter. The customer's usage would then be read manually by an employee. Number 2, removing the winter daily limit in the GS, general service, and firm sales classes. There was once a time where cost of service gas was considered a scarce resource. However, now it is plentiful, so it is not necessary to have this limit. Also, there have been certain customers that have preferred to be a sales customer but have approached the winter daily limit. At this time, there is no reason not to let them continue to be a sales service customer if they choose to. Number 3, removing the tracking of accounting requirements for the CO2 processing plant recovery. This is a cleanup issue since it relates back to 2005 and doesn't serve a purpose anymore. Number 4 is removing the extension area charge for Bryan Head. This expired back in 2014. Number 5 is removing the option for the company to provide temporary propane service. This service has been discontinued by the company due to safety concerns. Number 6, adding language for customers that have had prior fraudulent activity, bankruptcy, or won't provide identification to pay a security deposit of the greater of $125 or the highest month's bill over the last 12 months. High-risk customers need to pay a security deposit to mitigate risk. Once the customer has proven good payment history for a year, the security deposit would be returned to them. Number 7 is adding language for cost treatment for the high-pressure main extensions and service lines. This addition to the tariff is the company's current policy. This policy mirrors the intermediate high-pressure main and service policy. By adding the language of cost treatment, it provides transparency, consistency in administrating, and gives notice to customers. Number 8, some other proposed changes including rewording, referencing, punctuation, formatting, and grammatical corrections. These types of changes do not affect the substance or applicability of the tariff. Number 9, some of the other changes within the tariff, including the distribution non-gas rates, administration charge, transportation service class 35,000 decatherm moratorium, have been sponsored by another witness. To my knowledge, the changes I mentioned, number 1 through 8, no party has objected to, and number 9, Mr. Summers has addressed today in his testimony. The proposed changes are just, reasonable, and in the public interest. In addition, an order issued on December 31st, 2019 in docket number 19-057-T05 identifies a change to tariff section 2.01 firm sales service. So there is no additional need to change the time request for the firm sales service class in this general rate case docket. And this concludes my testimony.
Ms. Ibsen is available for cross-examination and commission questions.
Okay, thank you. Mr. Jetter, do you have any questions for Ms. Ibsen?
I have no questions. Thank you.
Thank you. Mr. Snar?
We have no questions.
Mr. Russell?
No questions. Thank you.
Mr. Meekum?
Just a couple of quick ones.
Okay.
I'm not sure I understood your summary on the moratorium, but looking at the legislative version of the tariff on page 5-11, and number 11 talks about the 35,000 decatherms required for any customer to begin TSF or TSI. Is the moratorium in lieu of that, or in lieu of this paragraph?
So the moratorium, Austin talked about it during his testimony this morning about the 35,000 decatherm limit for, I guess, the TS class. I believe that would have to be added into the tariff. I'm not sure if a modification to the tariff would be any different than a moratorium.
Okay, I'm just trying to figure out if this paragraph stays or goes, number 11.
I guess,
I think if the commission granted it, you'd want to modify this language a little bit to make it clear if the commission agreed to a moratorium. This
Well, if they
reflects
go
the
that
initial
direction,
filing.
I'm just trying to figure out.
And if they don't, I think that this would not be appropriately included in the tariff.
Okay, so
Depending,
would
it'll be governed by the
change.
rule, wouldn't you agree?
It would be different than this.
Depending on the commission's order.
Okay, thank you. And then on page 5-10, under 4.04, there is a supplier non-gas adder of $1.42.
okay.
Now, that hasn't, I didn't see that in your narrative testimony. I'm certain that Mr. Summers referred to it, but that's not been part of the TS tariff, has it?
No, that is an addition.
And do you know why?
That is what Mr. Summers discussed earlier today. Some of the supplier non-gas charges we would like to charge to transportation service customers. We would do that by adding this supplier non-gas adder to their firm demand charge.
But they normally don't use supplier non-gas services, do they?
That's not true.
What is true then?
They do use supplier non-gas services. For example, the peak, they use, I guess, gas during peak time, and we have peak hour services that are collected through the supplier non-gas charge.
Okay, but isn't that if they use service at peak hour times, aren't they penalized, and that's how the company recovers its revenue?
No, we have different contracts set up for peak hour service, and that is for different time periods of the year, and that is recovered through the supplier non-gas charge.
Or would be, because it hasn't been.
Yes, but it, just in general, it's recovered by the supplier non-gas charge, and we're, in this case, in this tariff modification, we would like to charge the TS class for that charge.
Okay, thank you. Is that all of your questions?
Nothing, yeah, that's it.
Okay, thank you. Major Kirk or Captain Freeman?
No questions, sir.
Okay. Any redirect based on Mr. Meekum's questions?
No, I don't think so. Thank you.
Okay, Commissioner White?
No questions. Thank you.
Commissioner Clark?
No questions, thank you.
Just one very minor question. So with respect to the manual meter reading fee, is there a cost for the initial removal of the transponder?
So, no, the company would just come out and do that, and then just from that point on, it would be $20 a month to send an employee out there to read their meter.
Okay, so your proposal is to just absorb the costs of the initial removal? Okay, thank you.
Thanks.
Thank you for your testimony this afternoon.
Thank you.
Anything else from Dominion?
We have no further witnesses. However, we're prepared to address the question related to providing a supplemental model, if
Yes,
now would be a
please.
good time to address it. The company's conferred with other parties, and we are able to prepare such a model and then circulate it to other parties for review. Our hope is that we could get consensus and just submit that by the end of next week as agreed upon. That is our hope.
I'm pretty sure that's sooner than we would have an order ready to issue, so
Okay, thanks.
I'll just look around the room to, assuming everyone's in agreement to that, assuming there can be some consensus around the model once it's put together. And if there's not, then I guess we'll have an issue to work through in a short period of time. Okay.
No objection, although I think we need to have such clarity as you can provide as to what we collectively ought to be putting in that model so that it's a task that we can accomplish as opposed to something we can debate about as parties. And it's pursuant to your request.
So you're looking for commission direction on this model?
Well, I think the
It
commission
came from-
asked for the model.
Commissioner Clark
Sure.
asked about it, so why don't I-
Yeah, what I'm looking for is for the record to reflect, with respect to the TS rate design, a scaling of each volumetric block rate by an equal percentage, consistent with the recommendation that is in Mr. Higgins' testimony, and also consistent with what Mr. Summers testified would be an approach that I think he said he could support it, but at least it would correct the error that crept in during his last the model run that we have in connection with his rebuttal testimony. So that's all I'm looking for.
I think we can do that.
Thanks for the.
I have no problem, just that definition helps though, so we all have an eye on the same task.
Okay, so there's no need for additional clarification that from anyone? Okay, thank you.
Thank you.
Mr. Jetter.
Thank you. The division would like to call and have sworn in Howard Lubo.
Mr. Lubo, do you swear to tell the truth? Thank you.
Good afternoon, Mr. Lubo. Would you please state your name and occupation for the record?
Howard E. Lubo, I'm a utility consultant.
Thank you. And, oh, I think your microphone may not be turned on.
How's that now?
That sounds better.
Okay.
And were you hired by the division to provide testimony in this docket?
I was.
And did you have an opportunity to review the filings made throughout this docket by other parties?
I have.
And did you create and cause to be filed with the Public Service Commission here in Utah direct and rebuttal pre-filed testimony along with direct exhibits 6.0 through 6.7 and rebuttal DPU exhibit number 6.0 rebuttal?
That's correct.
Do you have any changes or corrections you'd like to make to your pre-filed testimony?
No.
And if you were asked the same questions contained in your pre-filed testimony, would your answers be the same?
They would.
Thank you. I'd like to move at this point to enter into the record the pre-filed direct and rebuttal testimony along with the attached exhibits of Mr. Lubo.
Okay, please indicate if anyone has any objection to the motion. And I'm not seeing any, so it's granted.
Thank you. Have you prepared a summary of your testimony?
I have.
Please go ahead.
As I just indicated, I was retained by the division to review the DEU class cost of service and rate design in this proceeding, primarily as a consequence of the issues surrounding service and pricing for services to the TS class. The cost allocation process and rate design recommendations are now a major focus of this case. I've had previous experience in gas cost of service matters in state and federal proceedings, representing utility companies and state commissions. My testimony today reflects that experience, recognizing specific policies and practices that have evolved here in Utah. Having reviewed the DEU filed evidence, I performed an analysis of key factors driving their cost of service study and proposed rate design. While there's a range of accepted criteria and practices employed in the cost allocation and rate design process, ultimately, the Commission must find those procedures that result in fair and equitable outcomes based on established precedents and the evidence before it in forums such as this case. While various parties represent different constituencies with stakes of interest to their clients, the aims of the division evidence in this phase of the case are aligned most directly with the objectives of the Commission itself. That is, the division has no intended bias to privilege one group of customers over another. In this context, my findings and recommendations are proposed as a balancing of all customer interests within a framework of recognized regulatory policies and procedures. More specifically, my analysis leads to certain recommendations which are proposed for implementation in rates at this time, while other proposals are made as suggestions for improvements that may be achieved in the next DEU rate proceedings. Concerning the cost of service methodology employed by DEU, I have raised 3 areas for proposed modification: recognition of interruptible volumes in the DEU design day factor, use of a 50-50 weighting in the DEU hybrid allocation factor, and use of actual test year peak day demands as a superior basis for peak responsibility allocation factor. The first 2 recommendations are proposed for this proceeding, while the latter recommendation is proposed for consideration in the next DEU rate case. In my prepared testimony, I pointed out that a hybrid allocation factor is somewhat arbitrary, as there is little empirical evidence to support any particular percentage weighting. In this testimony, I mentioned that utilities have on occasion relied on such a weighting and have employed a 50-50 allocation, also recognizing that a range of alternatives can also be found. An intervener requested any specific analysis that I might have to support this claim that was made in my pre-filed testimony. And absent the time or the data necessary to perform that review, I responded by saying that this assertion was based on many cases in which I have been personally involved. Mr. Higgins specifically found that this representation was insufficient and proposed that my proposal be ignored in the absence of specific citations. Since Mr. Higgins seemed to be fixated on this specific testimony, apart from other points I addressed in support of this weighting, I reviewed a recent Southwest Gas case in Arizona where I had a role similar to the one in this case. In that proceeding, which was case number G-01551A-16-0107, Southwest Gas, in its own filed testimony before that commission, employed a 50-50 hybrid allocation factor in allocating the demand component of mains and services. I reference this case now not to sway this commission to a particular weighting of 50-50, but simply to recognize that there are a range of weightings that have been employed in similar cases in this jurisdiction as well as other jurisdictions. Of greater relevance to this case is the historical use of the 60-40 weighting recognized in previous DEU rates, as well as DEU's reliance on the weighting in its initial filing. In my surrebuttal testimony, I found that Mr. Higgins' observation that a modification of the weighting might be considered a bit punitive in light of the cost shifts otherwise under review at this time. I found that this testimony had merit and therefore revised my initial proposal to revert back to the DEU filing of 60/40, which is also implicit in historical rates. In another recommendation, I proposed that the recognition of actual interruptible use during actual peak period be reflected in the peak demand allocation factor. This is consistent with the previous findings of this commission, where it directed a recognition of interruptible usage in the construction of this allocation factor. The facts in this case support the finding previously made by this commission, and if anything, the basis is more compelling at this time. DEU has not experienced a design day peak condition in over 50 years. For many years, interruptible customers have enjoyed the benefit of gas deliveries even during actual peak period conditions. Ignoring this benefit in the allocation process, as well as a more general consideration of the access and use of these facilities, provides an unreasonable subsidy to these customers. Finally, I propose that DEU employ a peak day factor based on actual test period conditions rather than relying on design day estimates. This recommendation is more consistent with general industry practice and is specifically supported by the fact that the DEU design day represents a condition that is unlikely to occur. Actual customer usage is a reflection of those customers who benefit from DEU system facilities. For these reasons, and the reasons further developed in my pre-filed testimony, I recommend that DEU be required to develop and include actual peak day customer data by tariffs necessary for consideration by the parties in the next rate proceeding. Aside from the DEU cost of service analysis, I also reviewed the DEU proposed rate design and made recommendations which include a distribution of the DPU revenue requirement, a separation of residential customers from the GS class in the next case, and isolating TS customers with volumes falling below 35,000 decatherm threshold at this time. The recommendation to separate residential customers from the GS tariff is consistent with predominant industry practice, including at least some of DEU's own sister companies. As stated in my filed testimony, this separation provides for a more uniform or heterogeneous group of customers, provides for greater transparency, and has a more accurate basis to allocate costs and design rates for these customers, as well as those commercial customers remaining in the GS tariff. DEU should be directed to file data consistent with these tariff separations in its next case. Finally, in consideration of the rebuttal testimony filed by other parties, I modified my recommendation for the proposed tariff changes to be implemented evenly over a 3-year annual period. This concludes my opening comments.
Thank you. I have no further questions for Mr. Lubo. He is available for cross and questions from the commission.
Thank you, Mr. Jetter. Mr. Schnarr, do you have any questions?
Yes, I just have a couple of areas that I want to seek some clarification on. Mr. LeBeau, let's briefly discuss the design day throughput allocator, as that issue has been center point to some of the discussion in this proceeding.
Mr. Schnarr, could you bring your microphone a little closer?
Oh, sure.
Thanks.
I'm sorry. Mr. LeBeau, are you familiar with the Seaboard cost classification allocation methodology?
It's been a while, but yes,
And is the Seaboard methodology recognized in the industry?
it has been, yes.
And isn't your originally proposed 50/50 weighting similar to the seaboard method?
Oh, goodness, it's been too long. You know, when you look at cost of service, there are so many variables and ways in which cost allocation principles may be implemented and considered consistent with NARUC and other industry practice. You really have to almost go behind just the allocation factor itself, but also look at what facilities those factors are applied to.
But it is true that the seaboard method did some significant allocations based on a 50/50 allocation.
That's
percentage,
my
right?
memory, yes.
Thank you. Let's move to one other area, and that is related to what you just summarized in your testimony, the revenue requirement and rate design. I'd like to just seek a clarification on a couple of things you represented. First of all, just for context, it's my understanding that Dominion sought approximately $19.2 million as a revenue increase initially in its application. Is that right?
Correct.
And in the rebuttal testimony, I believe that was reduced or revised to a request of $17.5 million. Is that correct?
I don't remember that specific number, but I'll accept that.
All right. Now, at the bottom of page 5 of your testimony, and of your surrebuttal testimony, continuing over to page 6, you're asked to describe your current rate proposal, including the assumptions underlying that proposal. Is that correct?
It is.
What is the DPU revenue requirement you have assumed in responding to those questions?
Well, I originally took the initial outcome of the staff analysis, the division analysis, which I believe implied an increase of about $1.2 million. However, that was with a caveat that it had a position with regard to certain plant facilities that, if considered in the revenue requirement, would have essentially brought that number to zero or slightly negative.
All right. At line 145 of your surrebuttal testimony, you suggest that having considered current commission policies and using your assumptions, that the possibility would be that the result of this case may indeed produce rate reductions to the GS class of customers. Is that correct?
Nominal reductions, yes.
All right. That concludes my questions.
Thank you, Mr. Snar. Mr. Russell, do you have any questions for Mr. LeBeau?
Yes, I do. Thank you. I want to hone in on this topic that we've been discussing regarding the allocation of peak demand costs to interruptible customers. Your position and the position of various other parties has been clarified in the pre-filed testimony, so I don't want to spend a lot of time on it, but you acknowledge that Dominion does not plan for interruptible usage in its construction of a design day demand, right?
I do.
Okay. And nonetheless, your proposal would impose costs associated with the construction of that design day system on interruptible customers for whom that system was not planned, yes?
That's correct. Based on my testimony, I've indicated a consistent availability and use of system demand by interruptible customers, and there should be some recognition consistent with Commission past statement and policy that those benefits should be reflected in the cost of service.
I will admit I'm a little bit confused on this next point because it's not clear to me what proposals you're making with respect to this allocation for this rate case and which ones you are proposing be developed for the next rate case.
Okay, just to clarify that, for this case, I've indicated that the company's design day peak demand allocation factor be modified to reflect the actual use of interruptible customers during the actual peak day in the test year.
And so then tell me what it is you're proposing that the commission order the company to do with respect to the next rate case on this issue.
In the next rate case, I think along with other considerations as discussed by Mr. Summers, the commission should be able to have the opportunity to look at the potential use of an actual peak day allocation factor and the rationale behind that alternative.
And you're making that recommendation because you don't believe the commission has sufficient, that the record here is sufficient to develop such an actual peak day allocator, correct?
That's right. In discovery, the company indicated that, and Mr. Austin discussed, I'm sorry, Mr. Summers indicated in his testimony earlier today that that data is not readily available. It can be developed, but it was not developed for purposes of production of discovery in this case.
Okay, I want to talk for a moment about your proposal to impose those design day costs on interruptible customers in this rate case. You have included in your direct testimony various spreadsheets that contain the calculations supporting that proposal, correct?
Just to clarify, I don't 100% agree with the predicate in your question. What I'm proposing is that the system facilities employed by the company that relate to provision of meeting customer demand include interruptible usage as a reflection of the actual demand placed on the system in the test year and implicitly year over year as it exists in how the system is actually used. And I've reflected that adjustment at some level, in this case, by taking the company's design day factor and adjusting it for the interruptible volumes that were actually used at the time of the company's system peak.
And you've done that with respect to interruptible volumes used by the IS class as well as those interruptible volumes utilized by customers in the TS class, correct?
That's right.
Okay. And how have you sought to impose those additional costs on interruptible customers? What is the specific mechanism that the company will collect those additional costs?
Well, of course, for purposes of this case, we've assumed that there's a fair amount of linkage between the results of the cost of service analysis and ultimately the rate design that might come out of this case. So that's the bridge, basically, that would be relevant to how those costs would flow through into a somewhat revised allocation of cost that would be reflected in the design of TS and IS rates.
So specifically, you have proposed to increase the volumetric rate blocks in the TS class and to impose an additional an increase in the contract demand for TS customers to account for those additional costs, correct?
Implicitly, I've generally, as you know, supported DEU's recommendation with regard to rate structure modifications. And then I've gone on to say that while I might normally be inclined to support some of their rate structure adjustments, if this commission ends up at a revenue requirement level that produces nominal to no change in the overall revenue requirement, that the rate structure modifications are probably something that might better be deferred until the next case, along with a lot of the other matters that have been raised by DEU and the other parties.
Okay, but I really don't think that answered my question. What I'm trying to get at is, in your proposal to impose these incremental costs that you associate with interruptible customers' usage for the peak demand factor that you're proposing be imposed here, you're proposing to raise rates for all TS customers in the volumetric rate blocks and in the contractual firm demand factor, correct?
That's correct to the extent it's consistent with the pre-filed recommendations of how DEU intends to employ changes to that tariff.
But it's consistent with your proposal, right? I mean, you have submitted.
Excuse me, but I clarified that a bit, indicating that while I generally support the GEU rate structure recommendations, that I would specifically not make some of the modifications that DEU's made at this time, given the fact that there may be little to no change in the overall revenue requirement. But I would just simply, a simplifying way of answering that is I would spread that in a uniform way across the existing rate structure.
So you would, and so you would do it just like the way that you've proposed? I mean, I'm trying to understand, you're now offering what I think may be a different recommendation than maybe what you had submitted earlier, or are you not?
I don't think it's different.
Okay, I didn't think so either, but you seem to be pushing back on my question, which is, and maybe it's just easiest to go to your spreadsheet. Why don't you pull up DPU Exhibit 6.3, which was submitted with your direct testimony.
Yes, I have that.
Okay.
And I guess what I was alluding to is that this rate structure is really within the DEU model, and I've made certain changes in the assumptions, and this is the result of changes such as the inclusion of the interruptible volume.
Right. So it might be useful for us just to kind of walk through what this Exhibit 6.3 is. So you've got kind of four tables here. The table at the top of this exhibit is the base case that I believe Mr. Snar had asked you about, which includes certain adjustments made by the division, but not all of the adjustments that the division had proposed for revenue requirement, correct?
That's right.
Okay. And so that's what you call the base case. And then the second chart down is the base case, but with a design day factor to impose those costs on interruptible volumes, right?
Correct.
Okay. And then the third table down, and I guess I should say, you've also submitted various exhibits that correspond with each of these tables, right?
That's right.
Okay, so your Exhibit 6.4 corresponds with the table at the top,
That's right.
and 6.5 corresponds with the second table related to the design day with interruptible volumes, right?
And so on, yes.
Yeah, and so you've got these two tables at the bottom of 6.3, which correspond to your proposal in your direct testimony, which you no longer are proposing, relating to the 50/50 demand throughput factor, right?
That's right.
Okay.
So at this point, I think the focus would be on the second set of data within the 6.3.
Yeah, so in order to figure out how we get from the table at the top of 6.3, your base case, to the second table, which the only change you make there is allocating design day costs on interruptible volumes, right?
That's right.
Okay. And so to look at that, we would compare Exhibit 6.4 with 6.5, correct?
That's right.
Okay, and I'm going to ask that we do that. So let's pull up 6.4. And you are looking at a hard copy, and I've got a spreadsheet, and I'm gathering that probably at least half of the room has a spreadsheet, so I'll try to direct these questions so that we can deal with this both ways. So if we scroll down on the spreadsheet or turn on your hard copy to the part of that chart addressing the TS customer class.
That would be on page 5 of 8 of my exhibit.
Of your hard copy version. Okay. So there's a table that at the top says Utah TS, and then on the left-hand side of that table, it has something, kind of a table header saying from revenue run output, and those are company numbers, correct?
That's right.
And it's got block 1, 2, 3, and 4 with the block breaks in the TS class, right?
Correct.
And then down below, we have a line showing annual demand charges per DTH of contract firm transportation, right?
Yes.
Okay, so on the left-hand side, as we've established, those are the company numbers. And on the right-hand side, that's how you would propose to change the rate to account for your proposals. In this, we're looking at 6.4. The proposals here are some, but not all of the division proposed changes to the revenue requirement, yeah?
That's right.
Okay, so in order to figure out what you've done to impose the design day costs on interruptible volumes, we would look at we would compare the proposed rate in 6.4 with the corresponding proposed rates in Exhibit 6.5, right?
That's right.
Okay. And what we see when we make that comparison is that in order to impose those design day peak demand costs on interruptible customers, what you've done, or what you've proposed here, is an even volumetric, or an even increase for at each volumetric block rate, correct?
That's what it shows.
Okay, and you've also proposed to increase the annual demand charge per decatherm of contract firm transportation, right?
I believe that that's the result of the underlying assumptions in the DEU rate design model that I relied upon in reflecting these changes. I didn't independently crunch through all of this data. I relied on the DEU model and the representation made by DEU of how it was proposing to spread any level of increase that the commission might authorize.
But of course, DEU doesn't believe it's appropriate to impose design day costs on interruptible customers, correct?
That's its current position, yes.
Yeah. And so using that model in this way yields something of an odd result where we're, in an effort to impose interruptible design day costs for interruptible volumes, we're imposing additional charges for firm transportation customers, right? At least in this example?
Well, this goes to the very heart of DEU's testimony, and at some level mine as well, which is that maybe we don't have the best breakdown within tariff groups to be able to properly reflect underlying cost of service to the extent that that's going to be a primary driver of utility rate design.
Okay, I think we've explored that perhaps enough. I want to go back to your 6.3, if we may. walk through the, what each of these tables, or at least identified what each of these 4 tables is. But I want to kind of focus a little bit on the effects of the proposed changes here. Again, starting with your base case at the top, you note a 37.91% increase to the net cost of service collected from TS customers, correct?
That's right.
Okay. And a corresponding 3% decrease to those, that cost of service collected from the GS customers, right?
That's right.
Okay.
And again, I think it's important, based on the way you're asking me these questions, this is simply the raw output of the revenue, the cost of service model based on the differing sets of assumptions. That doesn't necessarily completely link up with the rate design recommendations. But go ahead.
Yeah. But this does tend to highlight, to some degree, the proposals that you have made in this docket, right?
Certainly, it's a sensitivity or scenario analysis as it's identified on the exhibit that shows the relative monetary impact of these different assumptions.
Okay, so moving from the base case to the design day that incorporates the second chart down, design day with interruptible volumes, which incorporates your proposal to impose design day costs on those interruptible volumes, we see a corresponding increase of 45.45% to the TS class, correct?
That's right.
And that's up from the 37.91%, right?
That's right.
Okay, and then in that second chart, we see a corresponding decrease to the GS class of 3.62%, right?
Correct.
In terms of the percentage increase, that's a relatively small change for the GS class, but a relatively large one for the TS class, yes?
Well, it's about 7%.
To the TS class?
Correct.
And then we see with the other 2 recommendations that you have below, and I do understand that the 50/50 demand throughput is no longer your proposal, but we see with those that both of those recommendations also result in further increases to the TS class net cost of service, correct?
That's right. And as you point out, the results of that analysis are now moot, given that I've proposed the 60/40 cost allocation basis.
Okay. Each of those changes would increase, and the change regarding the interruptible volumes would increase the TS class cost of service, in addition to the fact that TS class is moving towards full cost of service here, correct?
It's not in addition to, in my opinion. It's simply a reflection of the use of the system by these customers. So it's not in addition to, it's a integral component of the consideration of this usage in the cost of service study.
The division does not object to the company building a system aimed at a particular design day, does it?
No, well, I think that's the result of a process, and of course, it's been fairly robust in recent years. So the commission, or I should say, as a consultant for the division, as I understand it at this time, is that the division accepts the approval of whatever system design the company proposes that has been reviewed and accepted by this commission, and does not challenge that, those assumptions.
Going back to 6.3 for my last question, the 45% increase to the TS class that's represented there, that is your latest recommendation in this docket, right?
Yes.
Okay. I think that's all I have.
Thank you, Mr. Russell. Mr. Meekum, do you have any questions for Mr. LeBeau?
I think just one quick one. Mr. LeBeau, in your rebuttal on page 6, after you have talked about rate spread and so on, you say that the rate spreads generally conform with current commission policies and/or assumptions made in previous rate settlements, but you don't say what those are. What do you have in mind when you ask yourself that question?
Well, excuse me, what I had in mind was that a few things. The cost of service model developed by DEU has been relatively stable in terms of the construction of that model and major assumptions within it over a period of time. In that interim period and in the evidence in this record, I've thought about the direction of the commission that there should be some recognition to of the use of interruptible customers in terms of the access and utilization of capacity-related facilities that it may use during peak period conditions. And I thought about the hybrid allocation factor generally kind of settling, as Mr. Summers referred to it this morning, at around 60-40. And that's maybe varied somewhat over time in terms of what underlying assumptions have been made. But the companies looked at that as a compromise position that it thought, certainly as it filed its testimony, was a reasonable basis for the cost of service model. So those are the main things I was thinking about.
Okay, thank you. And you've also been in the room on page 7 of your rebuttal. You talk about the company's proposed increase uniformly being uniformly applied in the rate structure when taken as a whole, but that may yet come. But there's no evidence or exhibit in the record right now that shows that these increases, particularly to the TS class, would be applied uniformly. Is there?
No, but that's not unusual. Of course, the whole point of this proceeding is to get to a set of recommendations in the record that may be acted upon by this commission. And typically what occurs is that the commission, either in the form of a late filed exhibit or as a requirement of a proof of revenue, would lay out the parameters of the rate design it intends to have implemented, and the company would be required to produce the result of those findings.
Okay, I have nothing further.
Thank you, Mr. Meekum. Major Kirk or Captain Freeman?
No question, sir.
Okay. Ms. Clark or Mr. Saban?
Just very briefly, if I understand I just want to confirm in your testimony, I understand you to be supportive of the concept of bringing the TS class to full cost of service. Is that correct?
Yes, as that may be defined.
Understood, but the general idea is that as I take your testimony, you agree with the company that that each class should bear their full cost of service.
I do.
Okay. And I think I just heard you a minute ago say this, but I want to make sure I'm understanding you correctly. I think if I've understood your testimony, you agree with Mr. Summers that before you make decisions about specific intra-class breakouts or intra-class rate setting, you need to have sufficiently clear data to be able to make those decisions and make them in a credible and sustainable way.
I 100% agree with that, and I'm sure it's frustrating to the parties and the commission that we get to these cases and it's a component of a utility rate filing, and it's simply not possible to look at the scope of massive changes in a customer rate design inter and intra class. So I 100% support the company's notion that this needs a deep dive and further analysis, and I think the division has comparable views with regard to what needs to occur to bring this to a point for the commission to have sufficient evidence to make clear findings about what's good or bad about these proposals with regard to cost of service and rate design.
Thank you. Last question. You just noted earlier in response to, I don't remember which attorney, I think it was Mr. Russell's question, that as it relates to actual peak day data, you believe that the company should, for the next rate case, be developing actual peak day data that could be used to allocate, I think your words in your testimony are, essentially to allocate the...
To tariffs.
Right.
And the implication of that, just to be more clear about it, is that, as Mr. Summers pointed out, this isn't something that you just have available from internal records.
And I just want to clarify that exact point. To the extent the company does not have and cannot obtain peak day data for some of the classes, would you agree with me that if the company or the commission was going to do what you're proposing, it would have to be relying to some extent on estimates because there isn't data for every class showing a peak day for every class?
I do agree with that. And as Mr. Summers pointed out, it relies, by its nature, of course, it makes those estimates now with regard to design day data when it separates it out by various groups of customers. And of course, in the context of a rate case, we're talking about tariffs.
Understood. That's all I have. Thank you.
Mr. Jeter, any redirect?
I just have a very brief line of questions I'd like to ask you. And if you wouldn't mind just turning to, this is Exhibit 6.3.
Yes, sir.
And this is just to, I guess, clarify a little bit of something that's not necessarily intuitive here. In the GS class on each of these, and we can just look at even the top chart here, the top table, a 3% increase or decrease for a typical GS customer. Is it accurate that that would represent a 3% difference in that typical customer in that class, their total cost of gas service during a billing period?
Well, to be clear, it would represent the distribution component, not the commodity. So the impact on the customer when it looks at its total bill would be less than this.
Than 3%. And with that same that same difference between what's represented here as a percentage of the distribution cost as compared to total cost of gas service apply to all of the other classes, TS included? Let me rephrase that question.
I hadn't looked at it this way, and maybe it's in this record, but of course, when you're looking at large volume customers, the percentage of the distribution cost versus commodity may be skewed to an even lower weighting.
Okay, and that's what I was trying to get at here is a 45% increase intuitively sounds like a lot, but that may be a very small portion of their total gas cost over any period of time, a month or a year.
Well, that's right. It would not be the majority of the costs that these high volume, high load factor users face.
Okay, thank you. That's the only redirect I have.
Does anyone have any recross based on Mr. Jetter's questions? I'm not seeing any indication. Hey, Commissioner Clark, do you have any questions for Mr. LeBeau?
I just have a question related to the 60/40 allocation that, factor that we've discussed today. And I'm quite familiar with your SIR rebuttal testimony on the subject, but do you have anything more to say than you've said here with respect to Mr. Summers, the logic that Mr. Summers sees in using the system load factor as for the throughput percentage as opposed to 40%? In other words, 32 as opposed to 40.
Only this. It's nice to be able to, when you're a decision maker or a party in the case, to be able to have empirical evidence that supports some finding. So it's nice to be able to say, look to this kind of allocation factor. I don't find it particularly compelling. As a decision maker, I think I'd recognize this for what it is, which is a hybrid allocation that is designed to reflect diversity, system diversity among different kinds of customers. And whether it's 60/40 or 68/32, it's hard for me as an expert witness to say where this commission should come down in one place versus another. The only place I would maybe hang my hat on the 60/40 a bit more is that historically it's kind of skewed to that result. And if we're going to look at a lot of other factors in the next case and defer things that maybe each of the parties is recommending now for deeper consideration, I'd probably be somewhat biased more towards the 60/40.
Thank you. That concludes my examination.
Commissioner White?
I have no questions, thank you.
I don't have anything else. Thank you, Mr. LeBeau. Thank you for your testimony today. Mr. Jetter?
Thank you. The division would like to call and have sworn in Mr. Douglas Wheelwright.
Mr. Wheelwright, do you swear to tell the truth?
I do.
Thank you.
Mr. Wheelwright, would you please state your name and occupation for the record?
My name is Douglas D. Wheelwright. I'm a technical consultant supervisor for the Division of Public Utilities.
Thank you. And in the course of your employment with the division, have you had the opportunity to review the application as well as the filings from the various parties in this docket?
Yes, I have.
And did you create and cause to be filed with the commission direct and surrebuttal testimony in this docket?
I did.
Do you have any corrections or edits you would like to make to that?
No, I don't.
I would, if you were asked the same questions in that pre-filed testimony today, would your answers be the same?
Yes, they would.
I'd like to move to enter into the record the direct and surrebuttal testimony of Douglas Wheelwright.
If anyone objects to that motion, please indicate to me. I'm not seeing any objections, so the motion is granted.
Thank you. Have you prepared a brief summary of your testimony?
Yes, I have.
Please go ahead.
Thank you. Good afternoon, Commissioners. The Division of Public Utilities has reviewed the testimony and exhibits of the company witnesses as well as the testimony and exhibits of the intervening parties. The Division has also participated in meetings and discussions with company representatives and submitted data requests in order to obtain additional information and clarification on specific issues. In addition, the Division has hired Overland Consulting to help in the review and analysis process. Mr. Howard Lubo from Overland has provided written testimony and analysis on behalf of the division and has provided testimony in the hearing today. The company has stated that one of the primary goals or objectives of this phase of the case is to bring each customer class to the calculated full cost of service and has specifically identified transportation customers as the class that is being subsidized. The application states that large TS customers were subsidized and were subsidizing the new small customers in the class, and that movement of commercial customers from the GS class to TS in recent years is one of the primary reasons for the undercollection of this class in total. In response to data requests, the company provided a revised calculation to show the cost of service for TS customers with usage less than 35,000 decatherms compared to large use customers. This analysis showed that under the current rate structure, small TS customers are paying more than their fair share of the cost of service, while larger TS customers are being subsidized by the other rate classes. This new analysis was the exact opposite of what was originally presented as the reason for a moratorium on the new customers moving to this class. The company maintains the burden of proof to demonstrate the need for a change in the rate structure and has provided conflicting information in this case. If the smaller TS customers are meeting their cost allocation requirements, the company should be indifferent as to which customer class they fall into. The division supports the company's effort to bring all customer classes to full cost of service and believe that additional study and analysis is needed. Any additional analysis should also include a more detailed explanation and review of the potential impact of reduced GS sales volumes, how they could have, Any additional analysis should also include a more detailed explanation and review of the potential impact that reduced GS sales volumes could have on the company-owned supply provided by Wexpro. The division would recommend that the commission direct the company to complete a more detailed review and analysis of these issues and require the company to include specific options and alternative recommendations for a possible split in the TS class as part of the next general rate case filing. The division would also support a similar review and analysis of a possible split in the GS rate class as part of the next general rate case filing. The division supports the proposed reduction in the administrative fee for the TS customers, the allocation of peak hour cost to transportation customers, and supports the phased-in increase in the TS rate spread evenly over a 3-year period. And that concludes my summary.
Thank you. Mr. Wheelwright is available for questions and across from the other parties.
Thank you, Mr. Jetter. Mr. Snar, do you have any questions for Mr. Wheelwright?
No, the office has no questions.
Thank you. Mr. Russell?
No questions, thank you.
Mr. Meekum?
Yes, thank you. I've got a few. Good afternoon, Mr. Wheelwright.
Good afternoon.
So as I understand it, your view's been changed through this process as you've seen new evidence come in that the small TS customers actually are providing return above the average system return.
The data request that was completed by the company did show that small TS customers were providing, they're meeting their cost of service requirement, yes.
And adding, actually providing a return beyond the average system return.
They were higher than the larger customers, I'll say that.
Okay. When you say that there has been inconsistent evidence, what are you referring to?
Well, I think the initial application stated that small customers were the problem, and that they were the cause of that the TS class was being undercollected, was the movement of customers from GS to TS, that was the root cause of the problem. This subsequent analysis does not show that that is the cause.
So, in the initial filing, the company didn't address that division of the TS class, did it?
No.
It came in the response to data requests.
That's correct.
And it showed just opposite of what the narrative has been for many years, did it not?
Yes, that's correct.
Now, you heard Mr. Summers say that the narrative is shifting, correct?
Yes.
And then in your testimony, in your rebuttal, you say that the moratorium may not be necessary. Is that still your testimony?
The moratorium, I think, can go either way, depending on which how you look at this, and I can argue both points. I think the moratorium would be helpful to gain a clear understanding of those customers that are in that class. I don't disagree with that. However, if those small TS customers are meeting their cost of service, the moratorium may not be the best thing. So you can argue it both ways.
But they are meeting their cost of service, correct? So you would really need to argue that the moratorium's not necessary under those circumstances.
No, I wouldn't say that, because we don't know how many customers would be moving to that class. If we have, as Mr. Summers said, if we have an additional 450 or 500 or 1,000 customers that move to that class, that would cause a problem for the company. If we have 20 customers, I don't think it would be a problem, but we don't know. So the moratorium may make sense to freeze that until we get a handle on what's going on within that class.
For 3 years?
That's the problem that I have. 3 years is a long time. We've been talking about this issue for 10 years now, and now we're going to go an additional 3 years. That's one of my concerns with the moratorium.
Does that strike you as unreasonable?
I don't know if there's another option, because the company will file a rate case every 3 years. We can't do anything outside of a general rate case. So, given those parameters, I don't know if there's another choice that we have.
But you recognize that the moratorium will stop any movement whatsoever to the TS class and prevent customers from enjoying the savings that they have been.
There's a lot of moving parts to this. Customer savings, yes. There are also implications for the Wexpro agreement that we need to look at this. We need to look at this in total. So I don't think this is an easy answer with the moratorium. And like I said, I can argue it both ways.
Wouldn't the TS class achieve its full cost of service faster by having customers join it that are actually producing return above the average system?
I don't know.
Well, wouldn't it stand to reason?
The volumes of the smaller customers are not really significant. So I don't know I don't know what the correct answer is. I don't know if it would improve it, or if we had additional customers moving into that class, the exact impact. We need more study. We need more analysis.
But again, the direction, even for those small customers, even if it's a slight increment, it's still an improvement, is it not?
It could be, but again, we don't know what the impact's gonna be. If we have 500 customers, if we have 1,000 customers moving, I don't know what the impact's gonna be, or if we have 50 customers moving into that class. So it's a moving target that's difficult to try and get your arms around.
Doesn't the evidence show that the large TS customers are the ones that are underperforming?
Yes, it does.
Should there be a moratorium on anyone joining that class?
I don't think that's a problem. I don't think we have many 800,000 decatherm customers.
And that is a problem. If they're the ones causing the problem, and the ones who aren't causing the problem are prevented by the moratorium from moving, how is that just and reasonable or fair?
I think the charge of the company is to look at their rates and make them fair. If they have a difficult time analyzing the data, I don't know how long it's going to take to pull the data together, to do all this work. 3 years is a long time. That's a concern that I do have.
So what's the solution?
The first thing we need to do, I believe, is to gather the data. I don't know, again, the challenge is we don't know what's going to happen to this class if we don't put a moratorium on it. Yeah, based on some of the information, it looks like some of the smallest customers would have a decrease. So if that were to occur, there may be a flood of new small customers coming to this class. that would impact the analysis process. So again, I can argue it both ways. If there's, without a moratorium, we may have a flood of new customers. With a moratorium, nobody can come in. So I don't know if there is an easy answer. We're going to leave that up to the commission.
So what incentive is there to move quickly if we have a 3-year moratorium imposed?
To move quickly,
To move quickly to do the analysis you're talking about?
that's another one of my concerns. I would like to do this analysis quickly while we do have people who are engaged, people who are familiar with the case, people who are understanding the issues. If we drag this out for 3 years, it's going to be very difficult to get people involved and to get them motivated to even participate.
What confidence do any of us have that the collaborative process is going to be more productive than what's been happening in the last 7, 8 years?
We don't have any assurance. But I would hope, and it's my recommendation, that I would hope that the commission would order the company to move forward. And it may take that. We've been looking at this for a number of years. So it may take an order or some kind of direction from the commission to move this forward. Or as an alternative, the division could also act and initiate a proceeding to move this information forward and to gather that information. The other challenge that we have is the company has all of the data. We don't have that. So we do rely on the company to provide that information.
But who benefits from a moratorium?
I don't know who would benefit.
Well, the customers looking to make a change won't benefit, will they?
No. If one of the examples was the savings to school districts, if there was a moratorium, they would not be able to achieve those savings.
And as I said to Mr. Summers, I mean, those savings for the school districts was nearly $5 million in 2019. So all of those customers who yet may move, forego whatever the level of savings is that a benefit to them?
No.
What would you expect to happen to the number of TS customers if there's a moratorium?
If there's a moratorium, there won't be any increase in the TS customers.
Can you tell us what will happen to the TS class decatherms with a moratorium?
I would imagine the volumes would stay roughly the same as they are today. I don't think you're going to have any increases if there's no new customers.
And have you given any thought as to what would happen to TS contract demands with a moratorium?
I don't think there'd be any change with the moratorium to anything.
So how do you provide incentive to the company to do this analysis in less than 3 years? I mean, let me restate that. Does a moratorium give the company any incentive to do the kind of analysis you're talking about?
Not directly, but I think indirectly, they are motivated. We've been looking at this for a number of years. I think indirectly there is some motivation to get this reviewed and analyzed, and that this is a priority for the division as well.
This is the only area, well, let me restate that. Isn't this the one of, if not the only area where there's just a modicum of competition?
So what do you mean by that?
We're dealing with a public utility that is a sole single provider. The TS class actually enables customers to purchase their own gas on the market. And that won't be available for 3 years under the moratorium. Is that correct?
Yes?
So competition's gone. Is that correct?
Yes? Well, yes.
So whether it's the intent of the company or not to engage in anti-competitive activity, it's the result, is it not?
It's a consequence of the condition they're in today. If the commission decides that there needs to be a moratorium, there would not be the opportunity for people to move to that class for 3 years. I don't think that's unheard of.
Well, that's a good question. Where have you heard of it?
I don't have any specific examples that I have researched. Mr. Lubo and I were discussing, he's familiar with other situations where there have been moratoriums on specific rate classes in other districts, in other jurisdictions.
For 3 years?
I don't know how long they were.
Okay, I think I'm done.
Thank you.
Thank you, Mr. Meekum. Major Kirk or Captain Freeman, any questions for Mr. Wheelwright?
Yes, sir. You said that based on the new data that was available, it seemed that the customers in the TS class, the small customers in TS class were subsidizing the large customers in the TS class. Is that an accurate statement?
That's the way it looks, yes.
And what model is that based off of?
It was based on the company's model, and they did the analysis.
And that's not based on a 100% design day model, like Mr. Collins proposes.
I don't believe it is.
And so you're not sure under that model whether small TS customers are actually subsidizing large TS customers if the commission chose to adopt that model, whether that would
I
be
don't know.
accurate.
I don't know.
It's fair to say that from the beginning of the case to where we are now, we're not really sure what the accurate cost is then within the TS class?
There's been a lot of changes within the filing.
The division still supports a 46% increase to the TS class, is that accurate?
The division supports bringing all customer classes up to full cost of service.
But we're not exactly sure what the cost of service is what you just said.
We haven't filed, the commission has not ruled on the revenue requirements, so we don't know what the full cost is going to be for each class.
There's a discussion about a moratorium on letting new customers move into the TS class. If we don't really know what the cost of service is for the TS class, perhaps we should have a moratorium on changing the cost of service for customers until we figure that out first. Would that be a proposal that division would be open to?
I have not recommended that. I have not stated anything about that.
Thank you.
Thank you. Any cross-examination from Ms. Clark or Mr. Saban?
No questions, thank you.
Okay. Any redirect, Mr. Jetter?
Just a brief couple of redirect questions. You've been asked a number of questions about the effect of customers moving in and out of the TS class with or without a moratorium, and as well as potential TS customers that would move in or out of the TS class above the 35,000 decatherm limit. Do you have any ability at this time to know what the effects would be without knowing what the rate outcome, the rates that would be set as the outcome of this hearing would be?
No.
That's my only follow-up question. Thank you.
Okay, any recross based on Mr. Jetter's questions? I'm not seeing any. Okay. Commissioner Clark, do you have any questions for Mr. Wheelwright?
Yes. So regarding the moratorium, I'll call it equivocal, I don't mean that in a pejorative way, but recommendation regarding whether the commission implements it or not. Is that reflecting uncertainty on your part regarding the entirety of the information that's been presented on the TS cost allocations evidence as it's been presented in the case? In other words, do you lack conviction about this latest information that you've received from the company and the cost recovery in the small TS customer element, or is there some other reason for you to doubt whether or not a moratorium ought to be imposed?
I think one of the things that Mr. Summers said is the analysis that was done only looks at one small portion of this. We don't know if the split at 35,000 is correct. We don't know if the split ought to be 10,000 or 100,000. There are a lot of unknowns with the information. That was one run that was done by the company. It was done with the company's model, but we don't know if that's the correct spot. There's still a lot of unanswered questions.
Do you have a view of what kind of information would persuade you that in a way that you could say unequivocally to the commission that is your recommendation that we impose a moratorium because unintended consequences are going to result if we don't? Is there a scenario that would make this more clear that you can articulate?
The company has, well, let me qualify this a little bit. There's a lot of moving parts to this. One of the aspects that has not been explored very well is the Wexpro production. Wexpro has some caps on it, and we can't ignore that. That's part of the way the company has to do business. We need to explore that further and see how that's going to play into this whole scenario. So I think there's a lot of moving parts that we need to address and analyze and really understand clearly.
I don't have any further questions. Thank you.
Commissioner White?
Good afternoon. Just one brief question. Obviously, it's been outlined in pretty great detail, the kind of the pros and cons of this moratorium concept. This concept, is this something that the only possible installation of a moratorium would occur at the conclusion or the order of this rate case? In other words, is this something that could be monitored by the division or other parties and as to see what potential consequences would occur based upon the outcome of the order? Is that something the division has evaluated, or?
We haven't evaluated it. That certainly would be an option.
And what would you, without, obviously, I'm putting you a little bit on the spot here, but what might that look like in terms of, the monitoring, and what type of action or request would the division potentially make or other party to as that will be monitored?
Let me think about this for a minute. One of the challenges that you would have is there's only one chance during the year for customers to move from GS to the transportation service. Once they've made that election, it's too late. If we have 1,000 new customers who signed up, it's too late. And we don't have a choice to go back and say, wait a minute, we want to put a moratorium on this. So that's the challenge that you've got, where you've only have, if there were a provision where periodically we could see how many customers were moving to that class, we could monitor that on a regular basis and see we've had 100 customers this month, 200 the following month, 300 the following month. We don't have that luxury. There's one time a year when customers can move.
So potentially there'd only be like one bite of the apple a year.
One bite, yeah.
That's all the questions I have. Thank you.
I don't have anything else, Mr. Wheelwright. Thank you for your testimony.
Thank you.
Why don't we break until, let's just say 3 o'clock? By that clock, thank you.
witnesses, because I have one witness who's not here, and I'd like him to go ahead, so if I could kind of get an idea who's going to be up, that'd be great.
Sure, I guess we can talk about this before we go on the record then. I don't think any of us have any preference. So I was planning on going to the office next, and after that, I hadn't given much thought. But if any party has a preference to go after the office,
No, we don't
Let
need
us
to go
know.
after the office. I just need, I mean, we could go tomorrow as far as I'm concerned. I just need to
right?
be
Okay.
able to get him here at the right time.
Well, I've just kind of by default been doing cross-exam in the order of of UAE and US Mag, then ANGC, then FEA. Any objection to continuing that order?
I'll quickly respond.
I'm happy to adjust, though. I don't have any preference.
No, I'll quickly respond to that. Mr. Higgins, on behalf of UAE, is here and is ready to go after Mr. Daniel is done. On behalf of US Mag, Roger Swenson is on his way here. I don't know exactly when he'll arrive, and so maybe we can do Mr. Higgins and then move on, and maybe we can come back to Mr. Swenson, if that works for the other parties. I know that you guys have got a witness. I don't know whether any of the other witnesses here have time constraints where they need to get on and off today.
Yeah, is there anyone who would rather not be on tomorrow? I'm not seeing anybody. Yeah.
Mr. Daniels, but I think we're on the verge of taking care of him.
Yeah, he's next, okay. Okay, are we in good shape then? I think.
Well, we'll find out.
Okay. Okay, we'll be back on the record.
Okay.
And at this point now, we'll go to Mr. Schnarr for the office for your witness.
Yes, thank you. We'd like to call as a witness Mr. Jim Daniel.
Mr. Daniel, do you swear to tell the truth?
Yes.
Thank you.
Good afternoon, Mr. Daniel.
Good afternoon.
Would you state your name and, for the record, and your address?
My name is James Daniel. Business address is 919 Congress Avenue, Austin, Texas.
And with respect to this proceeding, by whom were you employed or contracted for?
I'm employed by Office of Consumer Services.
And in connection with this proceeding, have you had a chance to review the filings and documents related to the Phase 2 cost allocation and rate design issues?
Yes.
And as a result of that review, have you produced or caused to be produced testimony and exhibits for submission in this proceeding?
I have.
And would that include your direct testimony, which was submitted on November 14th of 2019, along with exhibits, and rebuttal testimony submitted on December 13th, 2019, along with rebuttal exhibits, and surrebuttal testimony submitted on January 6, 2020, along with exhibits. Is that correct?
Yes.
And do you have any corrections or changes to make to any of those documents?
I do not.
And if you were asked the same questions today, would your answers be the same?
Yes, they would.
Thank you. We'd like to offer those exhibits that have been identified for admission.
Okay, if anyone objects to that motion, please indicate to me. I'm not seeing any objections, so it's granted.
Now, Mr. Daniel, have you prepared a summary of your testimony?
Yes, I have.
Would you please present that now?
Yes. For several rate cases in many years, the transportation service customer class has been receiving significant subsidies at the expense of other customer classes. In previous rate cases, excuse me, it's allergy season in Austin and my sinuses are giving me fits. In previous rate cases, gradualism has been proposed to gradually reduce or eliminate these interclass subsidies. Those gradual plans have done little to reduce these long-standing subsidies. In this case, DEU initially proposed to eliminate the subsidies at once based on its proposed cost of service study. While DEU's objective to eliminate the interclass subsidies makes sense, DEU's cost of service is flawed. And I'll talk about several of the issues that I have with the cost of service study. The first is the design day throughput allocation factor. One of the more contested issues in this case is the proper classification and allocation of the costs related to
the Intermediate High Pressure Distribution System cost, or the IHP system. In its initial application, DEU classified 60% of the IHP cost as demand-related and allocated those on a demand allocator, and classified 40% as commodity-related and allocated those costs on a throughput allocator. This cost method recognizes that a portion of the IHP system is used to meet peak demand and that another portion is used year-round. As the 40% weighting factor of the throughput component decreases, more costs are allocated to the GS class and less cost allocated to the TS customer class. ANGC and UAE propose to reduce the 40% weighting factor to 32%, and the FEA proposes to reduce it to 0. The DPU originally proposed to classify 50% on design day peak demand and 50% on throughput. The DPU proposal is commonly referred to as a seaboard methodology. The DPU also pointed out that the demand-related cost should be allocated using a test year peak demand allocator rather than the design day peak demand. I believe DPU's original 50% recommendation provides the best resolution for this issue because it offsets some of the problems with using a design day demand allocation factor. Next issue is the allocation of general plant depreciation expenses. By underallocating costs to the NGV customer class, DEU attempts to hide another interclass subsidy. DEU has incorrectly allocated general plant depreciation and therefore underallocates costs to the NGV class. General plant depreciation expenses should be allocated based on the allocation of general plant, i.e., the plant that causes the depreciation expenses. Next issue is the allocation of costs to interruptible service customers. DEU is proposing to change the methodology of allocating demand-related costs to interruptible customers that was approved by the Commission in DEU's last litigated rate case, docket number 07-057-13. The company is making the same arguments in this case and does not provide any support for this change. The Commission should again reject DEU's proposal. Next issue is the revenue distribution. As previously mentioned, eliminating the interclass subsidies at one time will result in significant rate increases for some customer classes. Another highly contested issue in this case is whether gradualism should be used to mitigate these significant increases. Of course, the level of the overall revenue increase, approved or decrease approved by the Commission, will impact the need for gradualism. UAE's gradualism proposal of a 3-step, 2-year approach to eliminate the interclass subsidies is an acceptable proposal and should be approved. I would also propose that the percent increase in each of those steps be an equal 33.3%. Next issue is the GS rate design. DEU is proposing a major rate redesign of the GS class. At the same time, DEU is proposing to delay changes to the TS rate design due to anticipated customer migration issues. DEU has not properly supported the proposed GS rate design changes and has not shown the impacts on the various types and sizes of GS customers. As shown on my exhibit OCS 4.3D, the company's rate redesign proposal will increase some GS customers' bills by over 40%, while decreasing other GS customers' bills by 15%. For these reasons, I recommend DEU's proposed GS rate redesign be rejected. Next issue is the rate TBF class. Customers receiving service under rate TBF have the option of bypassing the DEU system and connecting directly with another pipeline. In order to retain these customers, DEU provides a rate discount under rate TBF. In my direct testimony, I demonstrate that one of the two customers taking service under rate TBF should no longer receive a rate discount. DEU did not rebut my testimony on this issue. The Commission should require DEU to move this customer from the discounted TBF rate to the appropriate rate schedule. Last issue is the rate TS customer class composition. DEU is proposing to limit the availability of transportation service in the future to only customers with gas consumption of 35,000 decatherms or more. This proposal, along with eliminating the subsidy received by rate TS, could cause small TS customers to move back to bundled service under rate GS. This customer migration concern is DEU's reason for not redesigning the TS rate design. I recommend the Commission disallow DEU's 35,000 decatherm minimum use provision on a permanent basis, and I have not been convinced that a moratorium is necessary. In addition, I recommend that the Commission require DEU to split the TS customer class into two transportation service classes, one for small customers and one for large customers. Thank you.
Mr. Daniel is available for cross-examination.
Thank you, Mr. Snar. Mr. Jeter, do you have any questions for Mr. Daniel?
I have no questions. Thank you.
Okay, Mr. Russell?
Yes, thank you. Much of the subject matter of your testimony in this docket has been the subject matter of other witnesses' testimony, so I'm going to focus my cross-examination on two issues. One is your proposal to use a 50-50 demand and throughput factor. You, in your direct testimony, did not take a position one way or another on any adjustment to the demand and throughput factor, correct?
That's correct.
And it was in your rebuttal testimony that you noted that the division's witness, Mr. Lubo, had proposed a 50-50 weighting factor, correct?
That's correct.
And it was in response to Mr. Lubo's testimony adopting that 50-50 weighting that you agreed with his reasoning and have adopted the 50-50, right?
That's correct.
Okay. And as Mr. Lubo testified earlier, it's no longer his position, correct?
Yes, I believe he's moved to 60-40%.
Okay. You have a copy of your direct testimony?
Yes.
I'll ask you to turn to line 185 of your direct, please.
I have that.
I should note that we're going to switch gears a little bit, moving away from the the demand throughput factor, and to your recommendation to impose peak demand costs on interruptible customers. And I want to explore one aspect of your testimony on that, which actually comes in response to the question that's posed at line 192. And you state, the question there is, what is your recommendation regarding the allocation of costs to interruptible customers? And you state that you ultimately that you support imposing those peak costs to interruptible customers, and I'm focusing on the last sentence here. Changing this allocation factor reduces the costs allocated to the GS class by approximately $54,000. Do you see that?
Yes, I do.
Does that number not seem low to you?
Well, I don't think so.
Okay. I will note that I walked through Mr. Lubo's Exhibit 6.3, which of course uses some different inputs than yours does, where the change from the division's base case, or at least the base case that was identified in Mr. Lubo's direct testimony, to this same allocation, imposing peak day demand costs on interruptible customers, resulted in something like a $2 million reduction in cost to the GS class. Did you review those exhibits?
I did not.
Okay. And just to figure out where this $54,000 number comes from, I think we get the answer to that in the question and answer immediately before it, which is where we started at line 185. The question is, has DEU provided the information necessary to allocate costs to the interruptible customers consistent with the commission's order in the 2007 docket, right?
That's correct.
Okay, and you point to OCS data request 2.18, right?
Yes, that's what I've used.
Okay, and you provide the result of that data request 2.18 in your, in your exhibit OCS 4.2D, right?
Yes. I believe that's a copy of the response to a data request.
Right. The information there is what was included in the attachment to the response, I think, to 2.18, if memory serves.
I believe that's correct. Yes.
Okay. In response to OCS 2.18, do you understand that response was providing information that calculates peak usage by the IS class or by all interruptible customers?
Not sure I understand the distinction you're trying to make.
Sure. Do you understand that there is a class of customers that is the interruptible sales class, the IS class, right?
Correct.
And there are also interruptible customers in other classes, specifically the TS class, right?
That's my understanding.
Okay. And do you understand, well, I guess maybe I should back up. Is your proposal to allocate peak demand costs limited to the IS class, or is it for all interruptible volumes?
Well, my proposal is to copy what the commission approved in the previous docket.
Okay. Do you know, and I've got OCS 2.18 here. The attachment provides the same table that you have on your first page of 4.2D. The response, the written response, provides the actual request and response. And maybe it'd be useful to hand that out. So I'll do that now. This will be marked as UAE Cross Exhibit 1.
Did we get a copy to the court reporter?
Okay, I've handed you what's been marked as UAE Cross Exhibit 1. And do you recognize this as the written response to OCS Data Request 2.18? I guess I should clarify, the UAE Cross Exhibit 1 is 2 pages. The first page is the written response to OCS Data Request 2.18. The second page was actually delivered as a separate spreadsheet document that was titled Attachment OCS 2.18. Do you recognize this document?
Yes, sir.
Okay. The request submitted by OCS sought a revised design day allocation factor calculation that includes an allocation to interruptible customer classes consistent with the commission's order in the 2007 docket, right?
Yes, it does.
Okay. Did you review this information when you received it?
I believe I did, yes.
Did you review it to determine whether you had received an allocation to all interruptible customer volumes, all interruptible volumes, or whether you received an allocation to interruptible customer classes?
I'm not sure I reviewed it exactly the way you described.
Okay. If you look at the second page of this exhibit, in the print down at the bottom of that table, the top line of that print says peak day responsibility based on contract demand, TS and TBF, or calculated peak. And in the parentheses, it says GS, FS, NGV, and IS, right?
Yes, that's what it says.
So what you received in response to the data request was information related to the peak usage of the IS on, or the usage of the IS class on peak day, but the contract demand for TS on that day, right?
Well, it doesn't distinguish between firm or, if the contract demand's firm or not, but that's what it says, contract demand.
Contract demand is firm demand, right?
Yes, interruptible customer may have some firm demand, but in addition to interruptible demand.
Okay.
An interruptible customer may have firm demand in addition to interruptible demand.
So the calculation that you identify in your testimony to get to this $54,000 number is based only on an allocation of peak day costs to the IS class, right?
Well, what it is intended to do is to allocate costs consistent with the commission's ruling in the prior docket.
And do you know whether the calculation that you provided does that?
I thought it did. If it doesn't, then you need to help me see where it doesn't do that.
Further questions?
Thank you, Mr. Russell. Mr. Meekum, do you have any questions for
I have
Mr.
none,
Daniel?
thank you.
Okay, Major Kirk or Captain Freeman?
No questions.
Okay, Ms. Clark or Mr. Saban?
I do. I have a couple of questions. Good afternoon.
Good afternoon.
Mr. Daniel, you indicate in your sir rebuttal testimony that DEU hasn't shown that a discount is necessary to preserve the NGV class and that therefore it should not be approved. Isn't that correct?
I did, correct, yes.
Okay. Would you agree, subject to check, that in 2013, the tariff rate for the NGV class was $5.43 a decatherm?
I'll accept that subject to check, yes.
Subject to check. And would you agree, again, subject to check, that the tariff rate for the NGV class is currently $6.58 a decatherm, which is approximately a 21.2% increase from that 2013 rate?
I can accept that.
Would you also agree, subject to check, that volumes from 2013 until now have decreased by 61.63%?
I don't know that, but I'll accept
Would you
it.
accept my representation for purposes of the questions?
Yes.
Thanks. And would you agree, again, subject to check, that your proposal would bring the tariff rate to $12.05 a decatherm, which is roughly a percentage increase of 83% above the current tariff rate and more than 100% over the 2013 rate?
I believe Mr. Summers made that calculation, yes.
Is it your position that an increase from $6.58 to $12.05 per decatherm will not adversely impact the NGV class?
It's a significant increase. Yes.
You've also acknowledged in your testimony that the Utah State Legislature has expressed support for discounting the rate to this class and I think you even cited the code, section 54-4-13.1 of the Utah Code, correct?
Yes.
Is it your position today that the commission should ignore the legislative support and the roughly 100% increase that you would recommend, that your proposal would result in?
That's not my testimony. The testimony is that in order to discount the rate, you have to show that it's necessary, and I have not seen anything that would indicate that.
I don't have any further questions.
Thank you. Mr. Snar, any redirect?
Yeah. Mr. Daniel, with respect to the NGV-related issues, isn't it true that your primary concern was the use of appropriate allocators to establish the what would be, in essence, the full cost that should be associated with that class?
Yes, it is. I think the cost should be allocated properly, and then if it's determined that a discount is needed, then you look at that.
And so if the cost allocation, if the application of appropriate cost allocations or consistent with your proposal would suggest a $12.05 rate, you're also comfortable with following the legislative initiative to discount that rate to whatever might be required or justified by a further analysis. Is that correct?
Yes, if a discount's necessary, I have no problem.
I have no further questions.
Thank you, Mr. Snar. Any recross based on those questions? No? Okay. Thank you, Mr. Daniel. Oh, Commissioner Clark, do you have any questions for Mr. Daniel?
Just relative to the discount you were just discussing, if that's imposed, then the cost that would otherwise be recovered, but for the discount, need to be allocated somewhere. Is that right? They need to be recovered through the other rates that the company...
Yes, it's be similar to the TBF discount. To get the lost revenues get allocated back to the other classes.
Just one other question, and this really is relates to the what I'll call the technical tariff changes that DEU witness Ibsen reviewed with us this morning. And I ask only because, as far as I'm aware, the office hasn't articulated any position with respect to any of those. And do you have a position, or are you aware of the office's position? Can you help us with that? And I'm particularly interested in one tariff modification. The existing language says that supplier non-gas cost allocation levels will be established in general rate cases, period. And the modification would be, and in other appropriate proceedings. And so I'm just wondering if the office has a position on the addition of that language in particular, if you're aware.
I'm not aware of that.
Okay. Thanks. That's all my questions.
Commissioner White?
I have no questions, thank you.
And I don't have anything else. Thank you for your testimony this afternoon.
Thank you.
Can Mr. Daniel be excused now?
Let me just ask if anyone in the room has any objection to that. And I'm not seeing any. So thank you for your testimony and safe travels.
Thanks.
Anything further, Mr. Snar?
No, nothing further.
Okay, then we will go to Mr. Russell.
On behalf of UAE, I call Kevin Higgins to the stand.
Good afternoon, Mr. Higgins. I hope our streaming interruption didn't cause you too much trouble this morning. Do you swear to tell the truth?
I do.
Thanks.
Good afternoon, Mr. Higgins. Could you please state your name and identify yourself for the record, please?
My name is Kevin C. Higgins. I am a consultant in the firm of Energy Strategies, and I'm here on behalf of UAE.
And you submitted pre-filed testimony in this docket, correct?
Yes, I did.
Specifically, you submitted direct testimony identified as UAE Exhibit 2.0, along with associated exhibits 2.1 through 2.4. Rebuttal testimony in the form of UAE Exhibit 2.0R, along with exhibits 2.1R and 2.2R, as well as surrebuttal testimony identified as UAE Exhibit 2.0S, correct?
Yes.
And do you adopt the testimony included in that pre-filed testimony as your testimony today?
Yes.
If I ask you the same questions today, would you give the same answers?
Yes.
I will move for the admission of those identified identified testimony and associated exhibits.
If anyone objects to that motion, please indicate to me. I'm not seeing any, so the motion is granted.
Mr. Higgins, have you prepared a summary of that testimony?
Yes, I have.
Please proceed.
Thank you. Good afternoon. My Phase 2 testimony primarily addresses cost allocation, rate spread, and transportation service rate design. I'll begin with cost allocation. There are two key threshold questions before the Commission regarding cost allocation, and they both pertain to allocation factor 230. Allocation factor 230 is used to allocate the feeder system, compressor station, and measuring and regulating station costs. These items comprise approximately 40% of distribution gross plant. There are two basic components or classifications that are apportioned to classes using allocation factor 230: peak demand and throughput. The first key question is whether peak demand should be measured based on design day or based on the peak date that occurred during the test period. In my experience, Dominion and its predecessor, Questar Gas, has consistently maintained that the proper measure of peak demand is design day demand. And that is absolutely correct, in my opinion. The design day deliverability is what the system was built for. If in the majority of years it is not necessary to use the full delivery capability of the system, that does not change the fact that that capability is standing by and ready to be used by the weather-sensitive classes if they need it. TS customers do not have a free option on firm service. They must contract and pay for firm service through a demand charge, whether they fully utilize all of their firm service or not. In contrast, GS customers are not required to commit contractually to a specific amount of firm demand. They pay for what they use. But rather, the customers in this weather-sensitive class can call upon the full deliverability of the system that was constructed to serve them during the extremely cold temperatures of the design day. Some parties in this case choose to ignore this fundamental fact. Instead, they recommend allocating peak day costs based on usage levels other than the design day. In my view, that is simply an attempt to shift responsibilities for the cost of a system constructed to meet design day demand away from the temperature-sensitive GS class for whom design day deliverability was built, and on to transportation and interruptible service customers. This proposed cost shift is without merit and should be rejected by the Commission. The second key question is what respective weightings should be applied to peak demand and throughput when using allocation factor 230. Coming into this case, Dominion advocated for a weighting of 60% on peak demand and 40% on throughput. This weighting is arbitrary. As UAE has pointed out in this case and the previous rate case, an allocation factor that blends peak demand and throughput is a clear example of the average and peak method. The average and peak method does not use an arbitrary weighting for the volumetric component. It uses system load factor for the weighting. This corresponds to the amount of the system that would be utilized if all customers consumed gas at a 100% load factor. As such, it is a proxy for base usage. The Dominion load factor is 32%, and that is what UAE is recommending be used for the volumetric weighting, system load factor, just as prescribed in the NARUC cost allocation manual. And I will note that ANGC witness Mr. Oliver, with whom I have never communicated prior to the filing of our respective testimony in this case, independently reached the very same conclusion I have regarding the appropriate weighting of demand and throughput, 68 to 32. And to its credit, Dominion has since revised its position and concurs with using this nationally recognized standard. In contrast, the division initially proposed that instead of the arbitrary 60-40 weighting first proposed by Dominion, an equally arbitrary 50-50 weighting should be adopted. This has the effect of punitively shifting even more cost to the TS class, notwithstanding the 45.5% increase already proposed by Dominion for the TS class in this case. The division has since pulled back to a 60-40 recommendation, but the office, which implicitly started out at 60-40, later gravitated to 50-50, following the division. On the other hand, Mr. Oliver and I have not changed our recommended weightings during the course of this case. This is not a coincidence, as our recommended weightings are not based on subjective judgment. An important related issue is the sub-question of whether interruptible customers should be assigned peak day costs. The answer is no. Assigning peak day costs to interruptible customers is as illogical as it is inequitable. First of all, the system is not built to serve interruptible customers during design day weather. As Dominion has made clear in its testimony in this case, interruptible customers would be interrupted on a design day. Second, the fundamental rationale for using a volumetric weighting in the average and peak method in the first place is that the volumetric component already allocates a fair share of fixed costs to interruptible customers. And I'm referring here not just to interruptible sales customers, but interruptible transportation customers as well. After allocating fixed system costs to interruptible customers through the volumetric component, it is a misapplication of the method to then turn around and additionally allocate peak day costs to those customers. Third, allocating peak day costs to interruptible customers effectively eliminates any difference in the cost being allocated to firm service as distinct from interruptible service. And if we no longer differentiate between firm and interruptible service in cost allocation, and the resultant pricing implications are adopted, why would any customer agree to take interruptible service going forward? And if customers were no longer willing to take interruptible service because it no longer made any economic sense, the Commission and the company would have to contend with how big a system Dominion would need to construct to ensure firm service on the design day. I don't know the answer to this question, but I'm confident it is a much bigger system than the one we have today. Let me turn now to rate spread and TS rate design. I am proposing to phase in the full cost-based increase to the TS class and the target increase to the transportation bypass firm class in 3 annual steps. Most, if not all, of the parties have responded favorably to this general idea of a 3-step phase-in with respect to transportation service. In my proposal, the step 1 increase would be 25% of the total TS increase in order to provide some time to address rate design issues within that class in steps 2 and 3. To that end, I recommend that the TS rate design for steps 2 and 3 of my proposed phase-in period remain subject to further analysis, either through an extension of this docket or other means that would allow for further examination of the relationship between TS demand and volumetric charges, as well as among the volumetric blocks, in setting the step 2 and step 3 rate designs. However, if the Commission prefers to determine the Steps 2 and 3 TS rate design in its final order without deferring that decision by extending this docket or by opening a new one, then I recommend that the Commission approve the TS rate design approach I presented in UAE Exhibits 2.3, 2.4, and 2.2R attached to my Phase 2 direct and rebuttal testimonies. As shown in these exhibits, which apply to different total revenue requirements, I recommend an equal percentage increase to each TS volumetric rate in each step. I also recommend that the firm demand charge be increased by an equal amount per decatherm of firm contract demand in each of the 3 steps. Finally, I do not believe it is necessary to split the TS class into small and large customer groups at this time. Over the years, I've seen conflicting analysis regarding the cost relationships between small and large TS customers. Consequently, I recommend maintaining a single TS class in this case so as to minimize the disruption to TS customers while further analysis is conducted. And that concludes my summary.
Thank you, Mr. Higgins. Mr. Higgins is available for cross-examination and commission questioning.
Okay, I think I'll start with Mr. Meekum. Do you have any questions for Mr. Higgins?
Yes, thank you. I've got a few. Hello, Mr. Higgins.
Hi, Mr. Meekum.
In your SIR rebuttal, around lines 41 to 45, you say that, you just noted that you don't want to split the TS class at this time, and you say that there's discordant analyses defining the cost relationships between the small and large customers in the TS class. Did I characterize that correctly?
Yes, you did.
Are you referring to the evidence in this case?
I'm referring to a certain extent to evidence in this case. I'm starting with. Certainly, there's been discussed at some length in this case the data responses prepared by the company that showed, according to the company's cost of service analysis, that the rates of return for smaller customers were greater than for larger customers. So that's one piece of evidence that's been discussed. In addition to that, in the company's direct case, the company raised concerns about the cost implications of smaller customers. And over the years, I've seen analysis prepared by the company that it has been referred to as cost curve analyses that shows the declining cost to serve customers as they grow larger. And so, to me, from my perspective, I think it would be useful and important to try to understand the relationship between the cost of service results that the company prepared in response to discovery and its prior analysis that shows significantly declining cost to serve transportation customers as they get larger.
Okay, thank you. You agree that in this case, at least in the initial filing, the company didn't split the class or provide any cost of service analysis with respect to the TS class in a divided way?
Yes.
And so in response actually to your data request, they came back using their model, and it showed, as you've already indicated, that the small customers were providing a 9.11% return. Is that correct?
Yes.
Is there anything, has anyone other than Mr. Oliver, provided a cost of service analyses with respect to that division? Is that the only thing on the record in this case?
I would say that I suppose it depends on where one draws the line in the record. The company has provided discovery to the Office of Consumer Services that shows its declining cost curves for customers as they get larger. So I don't know that anyone's introduced that discovery response into the record per se, but it's certainly been a subject matter that's been addressed as part of the proceeding, at least through discovery.
And you may have heard when you were listening that Mr. Summers indicated that the narrative that he provided in his direct, and actually well before that, has changed, that it's, at least based on the information in this case, the narrative was wrong. Did you hear that?
I did.
Okay. And again, in your rebuttal on lines 146 to 148, you talk about inconsistent information. Is that really the same sort of thing you're talking about? That the companies provided inconsistent information and that you think therefore it's premature to move?
Yes.
And I know I'm getting specific here, but with respect to the evidence that we've seen in this case, and I'm really referring to Mr. Oliver's exhibits that go to really to your data request, 201, there really isn't anything else that I'm aware of that shows how those cost relationships are between the small and the large customer, correct?
Well, I'm referring to it right here in this rebuttal that you're discussing with me.
And what do you mean?
In this rebuttal, I'm referring to the Dominion TS cost curve analysis, which indicates a significant decline in the cost per decatherm for TS customers as customer size increases.
I'm not aware that that's on the record.
That statement's on the record.
Okay, I agree with that. It's in your rebuttal. But as far as the backup data, I'm not aware that that's there.
I did not submit the data response itself as part of my testimony, I believe. Well, actually, hang on a minute. Actually, it is. Well, no, I just footnote to it, so I don't actually have the data response in my testimony.
And in that same response to your data request, 201, it shows pretty significant underperformance for the larger customers above 35,000 decatherms, does it not?
Yes.
0.75%, correct?
Correct.
Did you hear Mr. Summers testify, or did you read in his rebuttal, actually, that he didn't use cost curves for TS customers in this case?
Yes.
Okay. And would you agree that Dominion's cost curves do not address variations in customer load factors?
I agree.
And then I'm turning back to your rebuttal, lines 41 to 45. You suggest that a single TS class should be maintained to minimize the disruption to TS customers. What do you mean by that?
What I mean by that is that I am not prepared to recommend to the Commission that the entirety of any rate increase to the TS class should be just assigned to the larger customers, as Mr. Oliver has recommended. And we've talked about why I believe that is not an appropriate recommendation, at least at this time. And so, what I'm recommending essentially maintaining the class and providing a proportionate increase to the demand and volumetric charges in my initial step. And then, I've also recommended keeping the docket open to further explore the way in which the revenue requirement should be apportioned in steps 2 and 3. Yet at the same time, if the commission does not want to keep the docket open, then I have a default approach that is proportionate throughout the class. And, part of that is the fact that reaching full cost, whether it's at, UAE's recommended revenue requirement, and, even at the, the cost allocation that I'm recommending, is still going to be a substantial rate impact on TS customers. And I'm recommending to the commission that they not do anything to exacerbate that rate impact by making it worse for some sectors of the class than for others.
I appreciate that. Now, given the evidence in this case, if we do nothing, there's no splitting of the class, and a moratorium is imposed, doesn't that leave the small customers producing above the average system return and the large customers producing under, and therefore there's a subsidy in the class from the smaller to the larger? Is that a correct assessment?
That is potentially the case. However, at the same time, the data response that you're referring to was performed at current rates, which have current administrative costs, embedded in the analysis. And the company, as you know, has proposed to significantly reduce those administrative costs, which I support, and which provides proportionately a smaller percentage increase on smaller customers, all things being equal, because the admin cost is a larger a portion of their bill. So there will be some mitigation for the smaller customers just as a result of reducing the admin fee as proposed by the company. Whether there's a continued subsidy beyond that, really, I believe should be, part of the subject of, future analysis. Again, I haven't seen a mapping that reasonably connects the company's cost of service analysis to the declining, usage per customer cost curves that the company has developed, and I think that it would be useful to have some time to explore and understand that.
But in that time, there are a lot of customers that won't be able to move to the TS class if this moratorium is imposed.
Potentially, and let me, I think I was probably the first person in this case to use the term moratorium, and maybe I can clarify that a little bit. I suggested a moratorium as an alternative to a prohibition, because I understood the company's original proposal was simply to prohibit customers, with less than 35,000 decatherm usage from, moving in the future to the TS class. I suggested a moratorium, which, by the way, I don't believe would last 3 years, but would be 2 years under my proposal, because I proposed that it would go away when the TS class was at full cost rates, which, even though it's 3 steps, would actually occur in 2 years, because there would be an immediate first step followed by a second step and a third step, and that actually takes place over 2 years, starting from March 1st, 2020. So, but my notion of a moratorium was really for the Commission's consideration, because I feel that the more important issue in the larger scheme of things is to adopt a 3-year phase-in of moving to full cost. And to the extent that the Commission would be concerned that a 3-year phase-in would cause customers to migrate who otherwise would not migrate at full cost, then I suggested that a moratorium might be appropriate in combination with a 3-year phase-in. If the Commission's not concerned about that, then I personally would see that the moratorium would not be necessary. But it was really to defend the notion of having a 3-year phase-in and address any concerns the Commission might have about allowing migration to the class during that 3-year phase-in, which, as I said, I don't believe would be a 3-year moratorium, but rather a 2-year moratorium.
The assumption is that the rates are going to go up even for the small customers, small TS customers, correct?
The block rates would go up, the admin charge would come down.
Correct. But that movement in rates could dissuade people from making the move even without a moratorium.
Potentially.
But a moratorium is going to shut down what little competition we have in this, with this utility completely for however long the moratorium lasts. Isn't that correct?
Well, I don't know that it shuts down competition. I would agree that it would remove or blunt a competitive incentive for customers who have not elected to move to the TS class up to this date. Certainly for customers who already elected that option, they would still, of course, be participating in the competitive market. But I would agree that it would certainly impede customers who are currently GS customers and would desire to migrate to TS in the next couple of years. I would agree it would be an impediment to them.
That's all I have. Thank you.
Thank you.
Major Kirk or Captain Freeman, do you have any questions for Mr. Higgins?
Just a couple quick questions. Sir, would you agree that demand or capacity costs don't vary with throughput or annual usage?
Yes.
And although the peak and average methodology is recognized in the NARUC manual, would you agree that the NARUC manual doesn't advocate for its use?
Correct.
That's all. Thanks.
Thank you. Mr. Snar, do you have any questions for Mr. Higgins?
No questions.
Okay, thank you. Mr. Jetter?
I have no questions. Thank you.
Okay, Ms. Clark or Mr. Saban?
No questions, thank you.
Okay, any redirect? No? Commissioner White, any questions?
No questions, thank you.
Commissioner Clark?
No questions. Thank you very much.
I don't have any questions either. Thank you for your testimony this afternoon.
Thank you.
Mr. Russell, is Mr. Swenson here, or should we move on to?
Mr. Swenson is here.
Oh.
I would like a very brief moment to talk to him before we put him on the stand. I don't know if it's time for a break or if you wanted to go through to the end of the day.
Well, yeah, why don't I go ahead and ask parties about that, and we could go off the record for this, although it doesn't hurt to stay on, I suppose. You know, we have a public witness hearing at 6, so we could take a brief break and go till about 5:30 if there's no objection. On the other hand, if we're going to be back tomorrow anyway, if parties prefer to wrap up and have a little bit longer day tomorrow, I think from our end, there's no preference either way, and if there's no preference from anyone else, I think we would just plan to go till about 5:30 unless anyone indicates that they object to doing that. And I'm not seeing any objections, so why don't we take about 15 minutes right now, and then we'll plan to go until about 5:30, and then break for about a half an hour before the public witness hearing. And at this point, we'll go back to Mr. Russell for US Magnesium's witness.
Thank you. On behalf of US Magnesium, I call Roger Swenson.
Good afternoon, Mr. Swenson. Do you swear to tell the truth?
Yes, I do.
Thank you.
Good afternoon, Mr. Swenson. Could you state your name and identify yourself for the record, please?
My name is Roger Swenson. I'm an energy consultant that works for US Magnesium through my firm Equant Consulting.
And on behalf of US Magnesium, you submitted pre-filed testimony in this proceeding, correct?
Yes, I did.
And specifically, you submitted direct testimony that's been labeled as US Magnesium Exhibit 1.0, along with an Exhibit 1.1 that was attached thereto, as well as surrebuttal testimony that's been submitted and marked as Exhibit 1.0S, right?
Yes.
And do you adopt that pre-filed testimony as your testimony in this proceeding?
Yes, I do.
And if asked the same questions, would you respond the same way today?
Yes, I would.
Okay, and at this point, I will move for the admission of that reference testimony.
Okay, if anyone objects to that, please indicate to me. And I'm not seeing any objections, so the motion's granted.
Mr. Swenson, have you prepared a summary of your pre-filed testimony?
Yes, I have.
Please proceed.
The changes in gas transportation rates as proposed were very much a surprise to me, and that's not a good thing. My role with US Magnesium is to keep them from being surprised by energy cost changes. Energy costs represent a very large part of the cost of producing US Mag's product. US Magnesium contracts to sell its production out into the future years at a time. When we're surprised by a potential price increase of over $1 million a year to US Magnesium, the effects can be devastating to a company that cannot simply pass costs along. US Magnesium is not in a position to absorb that kind of a cost increase. For the rates to be so much different than what the company had been suggesting as needed change just a few years ago suggest a very different philosophy concerning developing rates based on costs that are caused by specific customers' usage on the system. The rates now, as proposed, seem to be moving towards less of a direct cost causality from the size of a pipe needed to serve a peak need to how much volume a customer uses. The volume of use is not the cost causality driver. The size and the cost of pipe in the ground is the cost causality driver. Shifting to cost allocation based on higher cost to throughput acts as a means to transfer costs from high load factor customers to low load factor customers. If that's the intent of these changes, driving rates higher, it would have been good to have the basis called out clearly. Of course, as has been called out in testimony by others in this case, customers groups with various load profiles all want the lowest cost to fall to their shoulders. I will not suggest that US Magnesium is any different, but if the philosophy to not base costs on direct cause and move towards customer subsidization, it is something that we need to understand, and again, so that we're not surprised as we move further on this path. As I said in my surrebuttal testimony, US Mag and all customers need to take into account the pricing signal that has been provided in this case. US Mag will take the price signal from the cost increase derived in this case with the cost allocation methods and will respond to those signals, as I expect many other large transport customers will have to do. I expect a reduction in the firm contract quantity to reduce costs. We just ask for time to make these adjustments to rates to be in effect with a 2-year transition as proposed by Mr. Higgins until the final highest rate would be imposed. This will give US Mag time to change its operation back to high levels of alternative fuels to drop the firm transport levels to much lower levels. We would also like to see a proceeding to investigate the changes in cost allocations in a proceeding to determine pass forward for rates. And from that, develop pass forward for customers to take away clear price signals from those rates. The most important thing I want to get across to the Commission from US Mag's perspective is that without access to a competitive market for gas supplies, US Magnesium would not be economically viable. We appreciate having that access. The other thing that I see as somewhat surprising in this case is about restricting access to lower cost competitive markets to certain customers. While it doesn't affect US Magnesium, it's something that we need to be, if it's something we need to be wary of, I need to be understanding that and taking that message to US Magnesium if there's some sort of prohibition that lurks somewhere in the subtext somewhere. That's it.
Thank you. Mr. Swenson is available for cross-examination and commission questions.
Okay, thank you. Mr. Snar, do you have any questions for Mr. Swenson?
No, we have no questions.
Okay, thank you. Mr. Jetter?
I have no questions. Thank you.
Okay, thank you. Major Kirk or Captain Freeman?
No, sir, no questions.
No. Mr. Meekum?
Maybe a couple. Mr. Swenson, do you?
And then our microphone's not picking you up.
It's on. I'm just too far away, apparently. Do you have Mr. Oliver's testimony in front of you?
I do not.
Okay. Yeah, I'm trying to decide if I'm going to give him mine. Well, let me see if I can do it without that, and we'll see how this goes. If it doesn't go well, we'll take up another topic. In your SIR rebuttal on lines 28 and 29 on page 2, you are rebutting Mr. Oliver's testimony. And you say that Mr. Oliver suggests in his rebuttal testimony that the rates as provided are devoid of price signals. Is that a correct statement?
That's what I took from his testimony.
Okay. Well, let me read what it says, and then and we'll go from there. It says, this is on lines 238 to 241 in his rebuttal, where it says, while correct price signals may be an appropriate rate design consideration, the record of this proceeding lacks any evidence regarding what price signals should be conveyed to customers. If it says that, that's not exactly how you represented it, is it?
Well, I don't want to put words in Mr. Oliver's mouth. When I read it, I got the implication that there was a void of price signals being sent. And as you can tell, I respond to that void of price signals in a way that I hope comes across, because we got the signal. So I'm not arguing that if he was saying that there are price signals.
Okay. No, we understand your testimony that you are taking price signals where perhaps the company thinks you shouldn't be, but when the rates go up, no matter what it is, it's going to have its effect. Anyway, let me simplify. I know that I suspect that you looked at your own answer to USM 2.01, correct?
Yes.
And it showed that and you had asked for an analysis of the returns for customers who take more than 800,000 decatherms and those who take fewer than 800,000 decatherms. Is that correct?
Yes.
And the result was that those customers who were taking over 800,000 produced a negative return of 2.54. Is that your recollection?
I don't remember the number exactly, but it was a surprising result to me based on what I had been given as earlier data about what rate increases were going to come to large customers.
Okay. So I'm looking at ANGC Exhibit 2.02R, where Mr. Oliver compared the various requests of the division, UAE, USM, and I'm just referring now to your request, which, subject to check, it produces a negative 2.54% for those taking more than 800,000 decatherms.
Subject to check.
Okay. And I know, well, you may have heard, I'm not sure at what point you entered, but UAE's 2.01 shows that those taking fewer than 35,000 decatherms produce a return of 9.11%. Does that sound familiar to you?
I think I heard Mr. Higgins say something about that, but I don't know.
Okay. I think I'll leave it at that.
Thank you, Mr. Meekum. Ms. Clark or Mr. Saban, any
No questions, thank you.
questions? Okay, any redirect, Mr. Russell?
Thank you.
Okay, Commissioner Clark, any questions?
No questions, thank you.
Commissioner White?
No questions, thank you.
And I don't have any either. Thank you for your testimony this afternoon.
Thank you very much.
Okay, I think we will go to, you don't have anything else, Mr. Russell, do you?
I do not, thank you.
Okay, we will go then, I think, next to the federal executive agencies for your witness.
Yes, sir. FEA calls Mr. Brian Collins to be sworn in to testify.
Mr. Collins, do you swear to tell the truth?
I do.
Thank you.
Good morning, Mr. Collins. Would you please state your name and occupation?
Brian C. Collins. I am a principal with Brubaker and Associates Incorporated.
And you were hired by the federal executive agencies to provide testimony in this case, is that true?
That's correct.
And have you had a chance to review the filings of the other parties regarding the Phase 2 portion of this hearing?
I have.
And have you created and caused to be filed two different testimonies in this case? First, the direct testimony labeled FEA Exhibit 2.0 and Appendix A, and also your rebuttal testimony labeled FEA Exhibit 4.0.
Yes.
And do you have any changes or corrections to those pre-filed testimonies?
I do not.
Well, if you were asked the same questions today, would your answers be the same?
Yes.
FEA moves to enter into the record FEA Exhibit 2.0 and Appendix A and FEA Exhibit 4.0.
If anyone objects to the motion, please indicate to me. And I'm not seeing any objections, so it's granted.
Thank you. Mr. Collins, have you prepared a summary of your testimony?
I have.
All right, thank you. Would you please present that?
Thank you. Good afternoon, Commissioners. A summary of my direct and rebuttal testimonies is as follows. After the utility's overall cost of service or revenue requirement is determined, a class cost of service study is used to allocate the total cost of service among the utility's customer classes. To the extent possible, the utility's rates for its classes should be based on each class's respective cost of service. However, in instances where a full movement to cost of service would cause rate shock for a particular class or classes, gradualism can be used to mitigate the impacts on customer classes. The company's class cost of service study used to allocate costs to customer classes does not best reflect class cost of service because of its reliance on annual usage or commodity volumes to partially allocate the cost of distribution mains to customer classes. Specifically, the costs associated with large diameter, intermediate, high pressure mains are allocated on throughput by the company, and the costs associated with high-pressure feeder mains are allocated using the peak and average method by the company, along with the costs associated with regulators, compressors, and related equipment. And the method that I referred to that they use for the feeder mains is commonly referred to as the peak and average method. And in this case, the company has weighted the peak or design day component of that composite allocator by 60% originally in its filed case, and 40% on throughput. And I think those numbers have now been changed and are using the system load factor. As a result, I recommend my proposed class cost of service study be used as a guide for the company's class revenue allocation. Under my proposed class revenue allocation guided by my class cost of service study, the TS class would receive an increase of approximately 4.17%, much closer to the system average increase. In my testimony, I discussed how costs are incurred by the company with respect to capacity. Capacity costs do not vary with annual usage. When a gas distribution utility is considering whether to engage in a particular expansion of its distribution mains capacity, it must first determine the proper size and cost of the expansion. In making this determination, the key consideration is the customer class's expected usage of the mains on the system peak design day. The expected usage on the system peak day dictates the need for an expansion as well as the proper size of the expanded mains, which in turn dictates the total cost of the project. The cost of the expansion is a function of the anticipated peak day usage, and that cost is the same regardless of when customers are expected to use gas. For example, the cost is the same regardless of whether customers are expected to use gas throughout the year or during only a part of the year, for example, the winter months. It is important that a class cost of service study reflect class cost causation. A study does this by allocating costs in a way that reflects how the system is designed. Annual usage is not a design criterion for a typical gas utility. Annual usage or commodity throughput is certainly a factor that should be and is considered in identifying the variable costs of operating the gas system. However, annual usage does not determine the amount of system peak capacity that is necessary to provide firm or non-interruptible service to every customer every day of the year. Rather, the actual physical size of the mains, the regulators, the compressors, and other related equipment is based on customers' contributions to the system design day demand. The system's capacity must be sized for design day demand so that all customers can utilize that system capacity to receive a firm, uninterrupted supply of gas every day of the year, including the day of the system peak demand. As a result, design day demand is appropriate to allocate demand or capacity-related costs to customer classes. I do not dispute that after the system is designed and constructed to meet design day demand, customers use the system to receive volumes of gas throughout the year. However, if customers expect supply sufficient to meet their design day demand, then they should pay for adequate distribution capacity to allow gas to be delivered every day to meet their expected demands, including days with above average demands. Otherwise, they will not be allocated adequate capacity to deliver gas on days with above average usage, which would be most cold days, and their service would be interrupted on all of those days. If the distribution system can meet design day demand, it can meet the firm demand of its customers on every single day of the year. Daily needs must be met, but the only way to ensure this will happen is through a system that is designed to meet design day demand. My proposed class cost of service study uses 100% design day demand to allocate the cost of large diameter, intermediate, high pressure mains, as well as the cost of high pressure feeder line mains to customer classes. Because design day demand reflects how the system is designed, it best reflects class cost causation, and my cost study is appropriate to guide class revenue allocation. I would also like to point out that it has been my experience that many states, approximately I think around 10 states that I've actually been involved with in my career, utilize a 100% design day demand allocator to allocate the cost of capacity, and they usually couple that with a customer component. It is important to recognize that the peak and average cost allocation method used by the company to allocate certain capacity-related costs results in customers paying different costs of capacity on a per-unit basis with respect to design day demand. By introducing usage into the allocation of capacity-related costs, higher load factor customers, such as the TS class, are allocated too much cost for capacity and pay a higher per-unit cost for capacity as compared to the system average per-unit cost. As an example, in this rate case provided in my server rebuttal testimony, TS customers are allocated a much higher gross plant cost for feeder mains on a per unit of design day demand as compared to the system average. This is shown in Table 4 of my server rebuttal testimony, where the system average cost is approximately $709 per unit of design day demand, while the TS class is allocated a cost of approximately $1,064 per unit of design day demand, which is about 50% higher than the system average per unit cost. In contrast, the lower load factor GS class is allocated a cost that is cheaper than the system average, or approximately $652 per unit of design day demand. An allocation method that results in different costs of capacity on a per unit of design day capacity basis for classes is inappropriate. The company does not incur a different cost of capacity to serve different customer classes. Under 100% design day demand allocation to feeder main gross plant costs, all firm classes are allocated the same per unit cost of capacity as the system, or $709 per unit of design day demand. This is also shown in Table 4 of my server rebuttal testimony. This is appropriate and reflects cost causation. It should be also recognized that if the P&A allocator is applied to the system design day demand capacity, the GS class would not have enough capacity to meet its design day demand. This is shown in Table 5 of my testimony. It should also be recognized that any concerns about impacts on customer classes resulting from 100% design day demand allocation can be handled with class revenue allocation and gradualism. It is first appropriate to allocate cost to classes as accurately as possible, and then gradualism can be utilized to temper any impacts that are of concern. My proposed class revenue allocation is based on the company's fully requested revenue requirement in my direct testimony, and I recommend that my proposed class revenue allocation be used to determine class revenue responsibility. Again, this is appropriate because my proposed class revenue allocation is guided by my cost of service study, which better reflects class cost causation with respect to the allocation of distribution main costs. My proposed class revenue allocation is shown in Table 2 of my server rebuttal testimony. This concludes my summary. Thank you.
We don't have any further questions for Mr. Collins at this time, and he's available for commission questions and cross-examination.
Okay, thank you. Mr. Russell, do you have any questions for Mr. Collins?
No questions, thank you.
Mr. Meekum?
I have none either, thank you.
Mr. Jetter?
I have no questions. Thank you.
Mr. Snar?
Yes, I have some questions. Good afternoon, Mr. Collins.
Good afternoon.
In your direct testimony at page 14, you address the question of how costs associated with the distribution system mains and related facilities should be allocated to customer classes. Is that correct?
You said on page 14?
I believe it's on page 14, yes.
Yes, I believe that's correct.
At lines 3 through 13 on that page of your testimony, you quote the Naru Gas Distribution Rate Design Manual at pages 23 and 24. As it defines distribution mains as a demand or capacity-related cost. Is that correct?
Yes.
Let me, if I may, have a copy of excerpts from that manual I'd like to share and talk about some of the provisions there.
Looks familiar.
I represent.
If we could just make.
This, I'd like to have this marked as OCS Cross Exhibit 1. I represent to you that it are excerpts from that Naru Gas Distribution Rate Design Manual. Do you recognize it, Mr. Collins?
I'm sorry, can we make sure you get a copy to the court reporter too? If we didn't already?
Yes, copy. Mr. Collins, do you recognize this as being excerpts from the manual?
Yes.
All right. Let me direct your attention to page 25 of the Naru Gas Distribution Rate Manual. Under the heading Demand or Capacity Costs, the first sentence states, demand or capacity costs are allocated to customer classes based upon an analysis of system load conditions on how each customer class affects such costs. Did I read that correctly?
Yes.
Okay. Could you now turn to page 27 of the manual? And I'd like you to read out loud the first sentence on that page.
Page 27.
Yes.
The most commonly used demand allocations for natural gas distribution utilities are the coincident demand method, the non-coincident demand method, the average and peak method, or some modification or combination of the three.
All right, and in the sections just following that, there's some definition provided, am I correct, on those three methods that have been called out, is that right?
That's right.
All right, with respect to the coincidental demand method, isn't it true that that allocates demand costs based on system peak?
It says at the time of system peak in the first sentence under section B, coincident demand method.
All right. There, and with respect to the non-coincidental demand method, I'd like you to look at that and review it briefly, and then I have a question for you.
Okay.
Okay. With respect to that method, is it fair to say that the non-coincidental demand method allocates costs to all classes of customers, including interruptible customers, based upon their actual peak, regardless of the times of the occurrence of that peak?
That's correct.
Okay. Now, let's further move on to the average and peak.
Okay.
And isn't it true that most of the parties in this proceeding have advocated the use of some form of the average and peak method as described on page 27, subparagraph D?
Right, either advocated or not opposed,
All
I
right.
believe would be a good description.
Okay, let's read together then subparagraph D. Could you read that section, average and peak demand method?
Sure. This method reflects a compromise between the coincident and non-coincident demand methods. Total demand costs are multiplied by the system's load factor to arrive at the capacity costs attributed to average use and are apportioned to the various customer classes on an annual volumetric basis. The remaining costs are considered to have been incurred to meet the individual peak demands of the various classes of service and are allocated on the basis of the coincident peak of each class. This method allocates costs to all classes of customers and tempers the apportionment of costs between the high and low load factor customers.
Now, just a couple of follow-up questions here. With respect to that portion of this hybrid allocation method, with respect to the portion that is tied to annual volumetric throughput, that would include an assessment of the throughput associated with interruptible services. Is that correct?
That's correct.
All right. And with respect to the other section, which is allocated based upon peak demand, that would not have any consideration for the interruptible users. Isn't that right?
That's correct.
So let me just summarize and see if you agree with my summary here. Using some form of the average and peak demand method would assign a portion of the demand-related cost to be recovered from all firm service, that is, sales and transportation customer classes, consistent with their peak demands, while also recovering a share of the demand costs from all customer classes, including interruptible customers, according to their throughput. Now, isn't that correct?
That sounds correct.
All right, thank you. That's all I have.
Thank you, Mr. Snar. Ms. Clark or Mr. Saban?
We have no questions. Thank you.
Okay, thank you. Major Kirk, any redirect?
Briefly, Mr. Collins, regarding interruptible customers under your proposed methodology, what would be the fair way to charge interruptible customers for their cost of service?
Just hypothetically,
Yeah, what's your proposal?
what's my proposal? If I recall correctly from my testimony, I believe I held the interruptible class, the IS class, at current rates. Would give them no increase. I believe both of the cost of service studies, the company's study that uses partial allocation of main costs using throughput resulted in a decrease for that class, and I think the 100% design day demand allocation also resulted in a decrease for the interruptible sales IS class. So my proposal was just to hold that class at current rates.
And what did you suggest hypothetically could be done to figure out what the cost of an interruptible customer is to the system?
Well, with respect to the IS class, I think there's only, I believe, 10 customers in that class. So if you were concerned about assigning, some costs of mains to that class, I think I said in my testimony that you can maybe do a special study where you basically do a direct assignment of costs to that class. Because there is a cost to connect, the interruptible sales class to the system, but that cost isn't very well represented by either the design day demand or a throughput allocator.
And also I wanted to ask you briefly about the NARUC model and the different models described in here that you just read. And just to clarify, does the NARUC model advocate for one particular method over the other?
I don't believe it does. I believe the main purpose of the manual is just to put a summary together of methods that are commonly used by utilities throughout the United States.
And in your experience, there's how many other states that follow a design day model?
States that I've personally been involved with, I've come across about 10 that again use design day demand allocation coupled with a customer component allocation of mains. With respect to peak and average, there's really 2 states that come to mind that I've experienced that model being used, and that's Illinois and Washington.
Thank you, sir. No other questions.
Thank you. Any recross, Mr. Snar?
No.
Okay, thank you. Commissioner White, do you have any questions?
I have no questions, thank you.
Commissioner Clark?
I have none. Thank you.
And I don't either. Thank you for your testimony this afternoon.
Thank you very much.
Major Kirk, anything else from the federal executive agencies?
Nothing further, sir. Thank you.
Okay. Thank you. Mr. Meekum?
Thank you, Mr. Chair. ANGC calls Mr. Curtis Chisholm.
Mr. Chisholm, do you swear to tell the truth?
I do.
Thank you.
Thank you.
Mr. Chisholm, could you state your name and business address for the record, please?
Yes, my name is Curtis Ralph Chisholm. My business address is 201 South Main.
Thank you. And did you prepare or have prepared under your direction testimony in this proceeding? Direct testimony consisting of 6 pages, which we've marked as ANGC 3, and filed on November 14th, and then a surrebuttal filed on January 6th of this year, consisting of 4 pages, which we've pre-marked as ANGC 3SR.
Yes, I did.
And if I were to ask you the questions that are contained in therein, would your answers be the same?
They would.
Are there any corrections that you're aware of that need to be made?
I know of no corrections.
Okay. Have you prepared a summary of your testimony?
I have.
Why don't you go ahead and give it, please?
Okay. I'm really concerned about competition in this natural gas market, and I would love to see a rate structure that's based on actual costs than what it has been in the past. It feels like such as the admin fee that is currently at $4,500 per year per meter. Meters that are tied to parcels
Secondary meters can be reduced down to like, I think, half price. But we've seen some of our customers pay over $250,000 a year in meter fees. One customer with, 50-plus meters, and yet you have large industrials burning 5 BCF of gas a year, paying $4,500. It's not cost-based. It's not economical for these small industrial customers to be paying these high admin fees that we don't see in other states and other utilities. Also, we believe that Dominion's idea of freezing the transportation rate, not allowing customers to join the TS class that don't burn 35,000 or more is anti-competitive. We believe it's baseless and serves only to penalize industrial companies from joining a class that serves them better and more fully recognizes their cost structure, where I believe it's been shown that customers burning less than 35,000 MMBTU a year provide a rate over the utilities required rate. Keeping customers in the GS class would essentially penalize them if they feel like they should join the TS class. The other anti-competitive feature in their current structure is the one time per year transfer between classes. We don't face this in any other market we have seen in the United States, having a restriction in that regard, and it is not cost effective for the utility or us. And in dealing with their employees, they don't like it because they have a lot of paperwork that hits them all at once, and also setting up all those customers to come over to the TS rate is they have not been able to hit the deadlines because of the burden in the past. And so it doesn't really serve anyone well. And also any increase in these lower tiers of gas use, the 200, the first 200 or the first 1,800, because these smaller industrials are paying the required rate, any increase will add to their burden. I think it will, actually, obviously would increase the rate to the utility above where they are now. The other issue is the SNG cost. I believe that Dominion is now asking from the TS class of customers. I believe that cost is covered in the imbalance fees. And so if they added another cost to the TS class and SNG cost, that would be a duplicative cost. And that, I think, is essentially my testimony.
Thank you. We would move the admission of ANGC 3 and ANGC 3SR.
If anyone objects to that motion, please let me know. I'm not seeing any objections, so the motion's granted.
Thank you. So Mr. Chisholm is available for cross-examination.
Okay. I'm going to go to Mr. Russell first.
No questions, thank you.
Okay. Major Kirk?
No question, sir.
Mr. Jetter?
I do have just a brief line of questions for you. As part of your job, you work for a company that provides gas supply to TS customers, is that correct?
That's correct.
And are you currently engaging with current GS customers to show them the options that they might have to move to the TS class?
We are, yes.
How many customers would you expect if the rate remains open and similar to what it is today to move to that class over the next 3 years?
It's a hard thing to estimate, but maybe over the next 3 years, maybe 400 or 500.
Okay, and I think that answers my question. Thank you.
Thank you, Mr. Jetter. Mr. Snar?
We have no questions.
Okay, thank you. Ms. Clark or Mr. Saban?
We have no questions. Thank you.
Any redirect? Mr. Meekum?
I have none.
Okay. Commissioner Clark?
Your estimate of 400 to 500 customers moving in the next 3 years, what is your assumption about the relationship of rates to cost of service in that answer? In other words, are you answering at current rates or
At current rates.
And so if the commission were to accept one of the proposals, one of the several proposals to, in a phased way, move to full cost of service for the TS class in the next 2 to 3 years, does that affect your estimate at all?
I guess it depends if our rates increase. Like, I think we're at full cost of service, for the smaller industrials. So I guess if it significantly increases, that might bring that down, but I wouldn't expect it to.
Thank you. No further questions.
Yeah, I just want to follow up on that. I mean, do most of your customers view these costs and commodity costs separately and get to that level of granularity, or do most of your customers look at combined rates, including all the costs we're dealing with here and commodity costs combined?
It depends on the sophistication of the customer, obviously, but a lot of them understand the costs incurred at the utility level versus the commodity cost.
Okay.
Mm-hmm.
I'm assuming commodity cost is the primary driver.
Right.
We're talking about here.
Mm-hmm.
Right, okay. That's all I have. Commissioner
Okay.
White, do you have any questions?
I don't think so.
Okay.
Thank you for your testimony this afternoon. Mr. Meekum.
All right, ANGC calls Mr. Bruce Oliver. Yeah, I don't have his number.
Mr. Oliver, do you swear to tell the truth?
I do.
Thank you.
Mr. Oliver, would you state your name and business address for the record, please?
My name is Bruce Richard Oliver. My business address is 7103 Lake Tree Drive, Fairfax Station, Virginia.
Thank you. And did you prepare and have to cause filed direct testimony in this proceeding consisting of 67 pages, which we've marked as ANGC 2, with attached exhibits ANGC 2.01 through 2.04, and attachments A and B, as well as rebuttal testimony filed December 13th, consisting of 39 pages, which we've marked as ANGC 2R, with ANGC 2.01R through 2.05R, and surrebuttal testimony filed on January 6th of this year, consisting of 37 pages, which we've marked as ANGC 2SR, with exhibits ANGC 2.01SR through 2.03SR.
I did.
If I were to ask you the questions that are in those three pieces of testimony, would your answers be the same?
I would, with a couple corrections.
Okay?
First, it's just one typo and a couple labeling considerations. First, there was a typo in my rebuttal testimony. See, I thought I marked it. And I've lost my notes on where it is. Bear with me just a minute. At I'm sorry, it's in my rebuttal testimony at page 22, line 458. The weighting for design day and annual throughput for DEU as proposed at that time was is shown as 60-60. It should have been 60-40. There's also a minor typo in my direct testimony on the next to the last line where it says, does this conclude your direct testimony? It should say rebuttal testimony. Okay. In addition, I'd like to clean up some labeling considerations on a couple of my exhibits. First, on exhibit ANGC 2.02, to be consistent with some of the other exhibits, under where it says TS and TSL, I would put the notation under TS less than 120,000 decatherms, and under TSL, I would put greater than 120,000. And I would also put a notation above the heading, or below the cost of service summary and allocations to rate classes that says, from DEU's response to DPU data request 11.01 attachment 5 COS summary. I also would note that in my rebuttal testimony, exhibit ANGC exhibit 2.01 on the second page should be 2.01R as opposed to just 2.01. I left off an R there. And those are the corrections.
Okay, thank you. So with those corrections, you adopt that as your testimony today?
I do.
Have you prepared a summary of your testimony?
I have.
Why don't you go ahead and give it,
Okay,
please?
I ask you to bear with me because during the course of things, I think we've eliminated a little bit, and I tried to adjust what I drafted, so I have some marginal notes I'll try to work in. The company's pricing and policies for transportation services are a key element of the cost of service and rate design issues in this proceeding. Essentially, all of the parties have accepted that the TS rates may need to be adjusted significantly upward. But how much upward is going to depend in part on the revenue requirement that the commission approves. If the commission cuts back the company's cost of capital, for example, that could have a noticeable impact on the overall increase and how much increase would need to be applied to TS customers or large TS customers, and therefore how much you'd have to phase in. It's possible that if the overall revenue requirement is much closer to maybe the division's position or lower, as some others have recommended, that we wouldn't need a phase-in, or we could do it in a two-step phase-in and have reasonable rate impacts. On the other hand, if you elect to approve the company's entire increase request, it may be appropriate to phase that increase over more than a 3-year period. The increases that result, even under Mr. Higgins' proposal, which I think has some appeal, are still fairly sizable increases. And I know most commissions would hesitate asking residential customers to bear 3 increases year after year of that magnitude. And So I think we need to be sensitive to how it impacts all sizes of customers. But that will necessarily be a function of what the overall revenue requirement is. ANGC has presented multiple cost of service analyses in this proceeding, all of which support a finding that small TS customers who use less than 35,000 decatherms per year are providing a greater than system average rate of return, not just slightly greater, but a rate of return in the magnitude of 9%, where the system average at present rates is less than 7%. Each of the analyses I presented were either prepared directly by DEU in response to data requests from UAE, the division, or U.S. Magnesium, or they reflect sensitivity analyses that I have developed based on DEU's cost of service analyses to test the sensitivity of the cost of service results for large and small TS customers. Again, all of those studies find small TS customers substantially outperforming large TS customers from a cost of service perspective. The return on rate base derived from small TS customers using less than 35,000 decatherms a year is consistently in the range of 9%. In some cases, it's even a little higher. The rates of return for the large TS customers in the most favorable scenario was 1.5% and may even be negative depending upon what scenario you look at. When the weighting of design day and annual throughput advocated by OCS, by DEU, and by other parties are considered, the rates of return for the small TS customers remain positive. Although the TS rate issues and TS cost recovery concerns are addressed by almost every party in testimony, ANGC is the only party that has presented and discussed actual cost of service results separately for large and small TS customers. We've done that for various segments of the TS class, cutting at 35,000, at 120,000, at 800,000, and we've shown how they stack up. And the more you isolate the larger customers, the worse their return gets. The more you isolate smaller customers, the higher their return gets. That information in and of itself, with the very strong differences between the small TS customer rates of return and those for larger TS customers, should be a compelling reason for segregating the classes. But my analysis doesn't stop there. I have presented analyses that show changes in use per customer for different size customers within the TS class. I have presented cluster analyses to see what groupings within the TS class are reasonably homogeneous. I have presented cost of service by segment. And I've provided, as I mentioned, sensitivity analyses to show how the cost of service would vary if you look at some of the different cost allocation proposals that have been presented. Again, the conclusion is consistent that small TS customers are more than paying their way. Witness Summers this morning essentially told the Commission that despite what's been a fairly reasonable time between rate cases, there are a lot of unresolved, an acknowledgement of unresolved issues from those earlier proceedings, that the company has not performed hardly any of the analyses necessary to address a split of the TS class or to redesign TS rates. I find that troublesome. They know that there's an issue there, and their answer is, well, we'll look at it for the next case. And when we get to the next case, what will the answer be? Will we really have any progress? Or will it be, once again, let's look at it in the next case? There are significant inequities within the current rate design, both on an interclass basis and an intra-class basis, that need to be addressed. The proposals that the company now supports and Mr. Higgins is presenting only address part of it. They are moving classes toward their cost of service. But there's very little evidence to support a conclusion that the charges within the classes and what gets charged to each individual customer within a class is reflective of their cost of service responsibilities. The challenge of rate design and the objective should be to have rates that are fair and equitable for all customers within a class. We've been told that, oh no, we can't do that because there's too much uncertainty when we have customers migrating. Well, if you'll forgive me and get in the vernacular, let's get real. Things are always changing. We have evidence already presented by the various parties that say if the rate proposals that have been presented are adopted, U.S. Magnesium may substantially change its demands. We're going to have, on average, 46% increases in TS customer volumetric charges. Customers respond to price increases of that magnitude. And not only that, any economist will tell you that customers not only respond immediately to the change, but there's a lagged response, and you can expect it to continue to have effects on how customers use their gas in the next several years. We've also been told that with changes in the rate design, we may expect TPF customers to come to the TS rate. There are lots of things that are going to change, even if you don't allow migration. And this idea that we're going to stop the world and have this pristine examination of a set of costs just is not realistic. Every utility in the country deals with constantly evolving customer class composition. This system in this area of the country has grown substantially. We need to be moving with it, not just trying to freeze it where we were and make some arbitrary determination. I mean, we even have a problem in this case in that the company's cost of service analysis assumes that more than 150 customers will shift from firm gas sales rate schedules to TS service in 2020. That's built into their cost of service analysis. If we adopt a moratorium or restriction on movement, it undermines the very premise of their cost of service study. Nobody's discussed that. They've already assumed they're going to have it, and now they're going to take that back. Well, you know, you can't stop the world. You can't stop progress. The proposals from the company to restrict movement are at best arbitrary, capricious, and in my assessment, unduly discriminatory. And they should not be adopted. The company's case with respect to TS rate schedule or TS rate structure is really built on a house of cards. They started the case with the perception that small TS customers weren't paying their way, that the growth in the number of customers was the problem in the TS class, and that wasn't the case at all. In fact, as more smaller customers have come into the class, we're finding that classes, the small customers, are more than earning their rate of return. They're not dragging down the class. They're not causing the subsidy to increase. And I'll accept some of the statements that, oh, well, the small customers don't have a big impact on the overall TS class, but it's not hurting them. Why do we need to block it? The inclusion of small, non-residential TS customers in the TS class is not the source of the company's TS cost recovery problems. The cost of service studies, including those that were performed by DEU for U.S. Magnesium, show that large TS customers are where the under-recovery is. Coincidentally, none of the parties that requested those cost of service studies for segments of the TS class, not U.S. Magnesium, not UAE, not the division, presented the results of those studies. If we're trying to find the answers to questions, or at least guide the commission as to what next steps should be, why isn't that put before you? It was only A&G that put it together in some kind of systematic format so that you could see what the story was. And the story is you don't need to be restricting small TS customers and further movement to that class. DEU's rate structure proposals focus on three key issues: the need to move to full cost of service and eliminate interclass and intra-class subsidies, the second part of which they push off to the future. If you're a customer and you feel that you're not paying your fair rates, is that a very satisfying answer to say, well, we'll address that 3 years from now, maybe? The second was to block customer transfers so that we could stabilize this class, which I submit to you won't have that result. And the third is to reduce subsidization within the GS class. And the company has taken a very minimal first step in that direction, but really to address that, you have a class that once again has huge diversity within the class and needs to be segmented. Almost all other utilities that I've dealt with have several breakdowns of their non-residential customer service. And to take the GS class and split it just residential, non-residential is a first step in that direction. Yeah. Unfortunately, the company hasn't come forth with the data that would allow any other party to make an affirmative recommendation in that case, on that issue. But it needs to be done, and it needs to be done near term, not in the next rate case. I also note that there's some questions about how the company has designed its rate proposals. And witness Summers' rebuttal testimony, he presents a table on page 5 that purports to show rate increases for different sizes of TS customers. Well, I looked at that, and the first thing that struck me was, how do you have one rate increase for each size? I've presented analyses in my direct testimony that document that there's huge diversity in the load factors for customers within the TS class. There are more than 100 customers that have load factors over 100%. There are over 90 customers that have load factors less than 20%. Yet within the company's largest 100 customers, you see load factors ranging from 23% to over 1,000%. How does that happen? Because it happens because of non-firm load, but it is an actual result. and it makes sense when you recognize a non-firm load. But there's large diversity. The same thing is true when you examine the load factors for smaller customers. Well, on average, their load factors may be in the 25 or 30% range. There are customers of reasonably small size that have 50 and 70% load factors. There are customers in that range that may take interruptible service and have even higher load factors. Load factor is a very important consideration. And witness Summers' surrebuttal table in his testimony doesn't address any of that. When I looked further as to what was going on in that exhibit, or in that table, I realized I had to reference his surrebuttal exhibit 4.01 SR. And in the detail of that, I found some surprising things. In the underlying data from which those rate impacts were calculated, there was an assumed 34% decrease in the fourth block volumetric charge for TS customers. That's a block that only applies to the largest customers, which are the customers that have been shown to have the worst rates of return. Now, when I go through a rate filing and there's a change of that magnitude, I would expect it to be discussed explicitly in the testimony. There's no mention of it. How can we do that? Now, the company says, well, we have a reduction there, but we ultimately get to the higher rate. But that means a 55% increase in the tail block charge for those customers in the last step. I'll guarantee you, when it comes to the time that we get that charge, they're going to be saying, hey, that's too much, we can't bear it. Now, yeah, there's a reduction that several people have mentioned in the administrative charge that does reduce costs for smaller TS customers. But there's a key difference here. The reduction in the administrative charge is based on the company's representation of a reduction in its cost of providing administrative services. Now, I still think they're overstated, but at least there was some cost foundation for that change. The change that was in that analysis and in the company's exhibit 4.01 SR for the fourth block of the volumetric charges has no cost of service foundation. Rather, it's directly counter to the cost of service.
I don't mean to interrupt, and I am trying not to interrupt your flow, recognizing how late we are in the day, but we've got some live surrebuttal happening with regard to Mr. Summers' surrebuttal testimony. And recognizing that that's not appropriate, I would move to strike prior testimony related to that exhibit, and I would also request a commission directive that further live surrebuttal on Mr. Summers' testimony not be permitted.
Mr. Meekum, do you want to respond to the motion?
Yeah, well, when else would he respond to the surrebuttal? So that's the final word, or do we get an opportunity in hearing to be able to express our position on the surrebuttal, which is new stuff? I think it's completely I think it's completely proper. And I don't know when else you would get a chance to do it. And in fact, we have hearing exhibits that actually address directly his phase-in. That is Mr. Summers' phase-in. So, I mean, unless you're going to have surrebuttal always be the final word, you're not going to allow parties to really be able to flesh out the positions appropriately.
Does any other party want to weigh in on this objection?
I have a comment.
Mr. Schnarr, go ahead.
Surrebuttal, from my experience, is the final word. However, surrebuttal is subject to cross-examination by all the parties as part of the proceeding. But we probably ought to recognize the difference between the opportunity to cross surrebuttal and instead invent an opportunity to provide Sir rebuttal.
Thank you, Mr. Snar. Before I come back to Dominion, any other party want to comment on the objection? Mr. Jetter?
I'd just like to, I guess, add a comment somewhat mirroring Mr. Snar's comment. The division has fairly consistently over time opposed to live Sir rebuttal unless it's been previously approved by the commission.
Do you want to add anything final?
I do. I want to emphasize, again, what Mr. Snar has, I think, ably pointed out, and that is the hearing exhibits that were offered previously in this hearing were in the nature of cross, and I think that is appropriate. I think in a witness summary, live Sir rebuttal clearly is not. It's a standard that I think all the parties here have been held to in the past and would ask the commission to do so now.
May I respond?
Sure.
In my experience, there has been live Sir rebuttal in order to ensure that the record has been fleshed out. They can cross-examine Mr. Oliver on anything he said here. But without it, I think you're going to have an inadequate record.
Anything further? Considering the time, considering that I don't want to put, once we move past this, I don't want to put any party in the position of feeling like they need to rush their cross-examination. I think we're going to be here in the morning. I don't see any avoiding that, and so I'm going to take the easy way out and defer ruling on this motion until first thing in the morning when we reconvene at 9 a.m. With that, anything else that we need to address before we adjourn until tomorrow and for tonight's public witness hearing?
No.
Okay, we are adjourned. Well, not adjourned, recess. Recess. Big difference.
You have to pay for it.